14th District Court for County of Washington, State of Michigan is now in session. All those plans for business before the court are near. The Honorable Judge Simpson presiding.
You may be seated. Ms. Zenda.
Good morning, Your Honor. Ally Zenda on behalf of the people. Your Honor, the people would waive any potential conflict to this honorable court in the office of the public defender. Though the people don't believe that there is such a conflict, people make this waiver in avoidance of any doubt.
Do you really still have to read that?
Just a little bit.
Okay, no, I was seeing you read
It's like
it. Really?
2 or 3
Really?
weeks,
It's like
yeah.
every week. I don't, okay, never mind.
Good morning, Your Honor.
Seriously?
Alex Warren Green on behalf of the Public Defender's Office. For our part, Your Honor, we also do not believe a conflict exists. If one were to arise, we would waive it
So you were my only choice.
and forever hold our peace.
Thank you, sir. The court, for its part, also does not believe there's a conflict either in addition to court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people of the state of Michigan versus Maurice Griffin. Are they in?
You're in senior.
This is Miss Cannon's case.
Your Honor, she is in the hallway. Assistant Public Defender, good morning. Assistant Public Defender Chinazi Carey, I can really, on behalf of Mr. Maurice Griffin, I'm just trying to look in the notes, Your Honor, and see.
Going to join us today?
That was her plan. That I know that was her plan for sure.
I don't know, have as many conversations you want on your way up.
Griffin.
I'm sorry.
Griffin.
Stephanie Cannon on behalf of Mr. Maurice Griffin.
Mr. Griffin, can you state your name, please?
Maurice Griffin.
Thank you. Your Honor, at this time, I need to adjourn this case for 2 weeks to allow some more discussion between me and my client and the prosecutor regarding today.
We're gonna need video read, so we can't do the 15th. I have to go for a second. I'll wait for the green sheet.
Thank you, Your Honor.
Probable cause will be adjourned to May 22nd, 2025, 9 a.m. Bond will continue in this matter. Thank you, Mr. Griffin. Court does call the case of the people versus Samuel Klosky.
Ally Zenda on behalf of the people, Your Honor.
Edward Dugas for Samuel Klosky.
Your name, sir?
Samuel Klosky.
Thank you.
Your Honor, at this time, I'd like to set this for a preliminary examination.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available the 20th.
We'll do our best, Your Honor.
Preliminary examination in person, May 20th, 2025, 9 a.m. That is before Judge Moore. I don't know if that date's gonna be right. Almost 13. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus James Worthington.
Morning, Your Honor. Jacob Kennedy on behalf of the people.
They're in town.
Good morning, Your Honor. Ellen Michaels on behalf of James Worthington is present over Zoom. We agree to proceed over Zoom.
Right. Good morning. Sir, can you please state your name?
James
Worthington.
And I'll need you to turn on a camera, please, sir. Thank you. All right, what are we doing?
We're asking to set this case for preliminary exams. Discovery is complete.
All right.
That's correct. Your Honor.
People have their witnesses available the 20th.
We'll do our best, Your Honor.
Preliminary
May-
examination.
I'm checking my
go ahead,
calendar. I'm
Jeff.
so sorry.
What were you gonna
Uh,
say?
I'm not available. May 20th, I have 2 exams already set that day in other jurisdictions.
So you'd rather go there than be with us? Okay, fine.
No, but
All
they
right,
asked
no,
me
okay.
first.
It's okay.
They-
I'm not
they
gonna
asked-
take any offense. May 27th. Will that work for you, counsel?
Checking. May 27th is great. Yes.
All right. May 27th, 2025, 9 a.m. That is before Judge Fresh Hour.
Thank you, Your Honor.
Thank you so much. Have a wonderful day.
Thank you. You too. Bond
Bye-bye.
continue.
Thank you.
Court calls case People versus Kurt Kwiatkowski.
Andrew Dennis for the state.
Really? Where is Miss Eckenroom? That's why, because she looks tall. Okay, they're in both courtrooms, but they need to have somebody here.
I understand, I'm just sharing.
Public Defender Chinazi Carey, I can rule Your Honor, on behalf of Mr. Kurt Kwiatkowski, correct.
Sir, state your name, please.
Kurt Kwiatkowski.
Judge, can we just approach very briefly? I know, start.
Record should reflect we had a bench conference in this case. It appears that there was no order on competency submitted to the court, so the court did not sign that off. I want one today. I will set a review hearing in this matter because that's going to start that process for August 7th, 2025, 9 a.m.
Okay.
And we'll continue.
Thank you, Your Honor.
And hold that. I don't want that to go out. I want that order.
Yes, sir.
Court does call the case of the People versus Brianne Cadell.
Ally Zend on behalf of the people, Your Honor.
Seriously. Cadell.
Brandon Bird.
I apologize, yeah. Well, good morning.
Good morning.
You and your honorable staff. Brandon Bird on behalf of Brianne Cadell. Can you please state your full name for the record?
Brianne Cadell.
Thank you. You're requesting an adjournment.
Yes, your honor.
Purpose?
Just got discovery yesterday. Has video to it. Want to review the discovery with my client and properly advise her.
May 22nd, 2025.
Your honor, respectfully, I'll be out of town on May 22nd.
29th,
Sounds good. Thank you, your honor.
May 29th, 2025, 9 a.m. without objection, bond continue.
Thank you, your honor.
Court does call the case of the People versus Victor Morris Gerard.
There you go.
Andrew Dennis, call.
Good morning, Your Honor. Trustee Stubb appearing on behalf of and with Victor Morris Gerard. Your Honor,
Your name, sir?
Victor Morris Gerard. Your Honor, we're asking for an adjournment to the 22nd. If we could, we're prosecutor and I are continuing to review the case and hopefully we'll have something done then.
All right, I don't have a problem with that. I will need a green sheet, sir.
On the adjournment, Your Honor, I'm sorry.
Pardon?
I'm sorry, I didn't have that prepared earlier. I will get it for you. Your Honor, could I, when appropriate, could I also address bond?
Probable cause conference, May 22nd, 2025, 9 a.m. as to bond.
Your Honor, previously he was out on bond and then you had ordered he do drug testing. He didn't do well on that part of the order and he is back at the Washtenaw County Jail. I have been in contact with Dawn Farm. I just had him sign some Dawn Farm. They have, he would like to go into their inpatient treatment. He was drinking a bottle of vodka a day before he was taken into custody. He would certainly benefit from inpatient treatment. Dawn Farm people said that they could have a bed potentially within a week. So if the court would be willing to amend the bond to release to inpatient treatment, and then if Mr. Morsterard somehow doesn't live up to that, then his bond could revert him back to the Washtenaw County Jail.
I don't have a problem with that. I would continue his bond. If you'll prepare an order just in case that he can be released to inpatient treatment, I have no.
That would be great. Thank you, Your Honor.
Thank you. Bond will continue at this time.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus is it Leorn McEwen?
Morning, Judge.
The prosecutor there, please.
Yes, I'm running on behalf of Leorn McCoy. Mr. Cohen, can you please state your full name for the record? Leon McEwen.
All right. You're requesting an adjournment, counsel?
Correct, Your Honor.
No, hearing no objection, May 29, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor. Thank you, Judge.
Thank you, sir. Court does call the case of the people versus Stephone Scott.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Scott. Can you say your name?
Stefano Scott.
All right.
Your Honor, discovery is complete. We're asking the court to please set this for exam.
People have their witnesses available the 20th.
We'll do our best, Your Honor.
Preliminary examination in person will be set May 20th, 2025, 9 a.m. before Judge. I'm sorry, Barr.
Yeah.
Before Judge Barr. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you.
Court does call the case of the people versus Jason Burkett.
Andrew Brandon for the people.
Morning, Your Honor. Christina Costantino appearing on behalf of Jason Burkett. Mr. Burkett, can you state your name for the record?
Jason Matthew Burkett.
Okay.
So just as the date and time set for PCC, at this time, we would be asking for an adjournment of the PCC. There is some additional investigation that I believe needs to be completed.
That objection, 22nd or 29th?
Either one. Either one works, Judge. Whichever the court wishes. Do you have a question?
Of course. 22nd, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Court calls the case of the people versus Tara Sims. Saxon. Is she by Zoom or is she here? Anywhere in the building? Yeah, please. Controlled substance possession.
Apologies, Your Honor. Tina Saxon on behalf of Ms. Sims.
Your name, ma'am?
Tara Sims.
Thank you. All right, what are we doing?
Your Honor, I'm asking for a preliminary examination date, and I believe I
Pardon?
have, I'm asking for a date for preliminary exam, and I believe I have all of discovery.
All right. People have their witnesses available the 20th. Preliminary examination will be set May 20th, 2025, 9 a.m. That is before Judge Moore. Bond will continue.
Thank you, Your Honor.
Jeff. Court, that's called the case of the people versus Nyland Mitchell.
Good morning, Your Honor. I plan P65879, appearing on behalf of Mr. Mitchell. Please state your name for the judge.
Nyland Mitchell.
Your Honor, we're requesting an adjournment. I was just retained last night. If this court has no issue with that.
Probable cause conference in this matter will be adjourned. 22nd work for you, counsel?
Yes, it will, Your Honor.
May 22nd, 2025, 9 a.m. Bond in this matter will continue.
Thank you. Your staff, stay safe, Your Honor. Always a pleasure.
Thank you. Close it up. Just kidding. Court does call the case of the people versus Jeffrey Stoops.
Ally Zend on behalf of the people, Your Honor.
Edward Lucas on behalf of Jeffrey Stoops in 1422.
Ms. Kate. That'd be anybody from the PD's office.
Sorry, I was trying to see what was left. Assistant Public Defender, Chinasi Carey, really on behalf.
Your name, sir?
My name is Jeffrey Allen Stoops, sir.
Thank you.
Your Honor, in my matter, we're looking to set that for a preliminary examination. I believe Kate was also going to set hers for an exam.
And that's correct.
So the parties, all discovery is complete.
To my knowledge, and speaking with Ms. Pate, I believe it is.
People have their witnesses available on the 20th.
We'll do our best, Your Honor.
Preliminary examination in person will be set May 20th, 2025, 9 a.m. before Judge. Okay, bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
You're gonna do what? Just have to fill that out exactly like that.
Like you copy the exact same thing.
Hmm?
Copy the exact same thing.
Same thing, right on this one, and then I'll sign off once it's done. Got it? Court does call the case of the people versus Alan Ballou.
I think it might be counsel. It's your.
Hello.
Good morning, Your Honor.
B-E-A-L-L, Alan.
Yeah.
A-U-L-I-E-U. Sir, how is your name pronounced?
Ballou?
Ballou.
Yes.
Assistant Public Defender, Chinasi Carey, on behalf of Mr. Ballou. Mr. Ballou, could you state your full name for the record, please?
Alan David Ballou.
Your Honor, we are asking for an adjournment. We have yet to receive discovery in this matter, so we are hoping 2 weeks. Okay.
Probable cause conference will be adjourned May 22nd, 2025, 9 a.m. That is, yes, at 9 a.m. Bond.
Thank you.
See? Wasn't it hard, right? Court does call the case of the people versus Shane Stout.
Jacob Kennedy on behalf of the people.
Morning, Your Honor. Edward Lucas on behalf of Shane Stout.
Shane Stout.
Thank you.
Thank you, Your Honor. I'm looking to obtain discovery. I'm asking for an adjournment.
Probable cause conference will be adjourned May 22nd, 2025. 9 a.m. On continue.
Thank you, Your Honor.
Thanks, Your Honor.
Court calls the case people versus Robert Branscombe.
Jacob Kennedy for the people, Your Honor.
I can really, Your Honor, on behalf of Mr. Brent. Thank you.
I don't think it's gonna matter because I don't think he's here.
Yeah, I don't think so, Your Honor. No, and unfortunately, Your Honor, Ms. Perenni did send an email and tried to contact our client and with no luck. So we have no explanation for his failure to appear.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately.
Thank you, Judge.
Case of the people versus Anthony Flanagan.
Good morning, Your Honor. Zachary Ward on behalf of the people.
Morning, Your Honor. David I. Goldstein appearing on behalf of the defendant.
Your name, sir?
Anthony Flanagan.
Thank you.
Your Honor, this matter is before the court today for a competency hearing. When I arrived this morning, I had not received any documentation, but Mr. Ward did provide me with a copy of the most recent report. And I will just say parenthetically, apparently there was another report earlier in this case that I never received. So I'm guessing it's going to the public defender's office, even though I'm counsel of record. But I have reviewed the current report, the one dated April 25, with my client, and we are willing to proceed based upon the findings in that report.
Then the finding in that report upon its review is that the defendant is no longer incompetent, and he's competent to stand trial.
I would also stipulate to the court's use of that report, and I have prepared a proposed order, which hopefully gets to the report.
Yes, it did. Court, based upon that, will find that the defendant is competent to stand trial, would specifically indicate that at this time, the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. All right. So what do you wish?
Mr. Ward and I discussed this, we're asking for a PCC so we can figure out the next step. I know you're setting ones for the 22nd. I was hoping for the 15th, but if the 22nd is the first available.
I mean, I can set it for the 15th.
Yeah, we don't need much time.
Will that work for you? Sure.
That's
Probable cause conference will be set May 15th, 2025. 9 a.m. Bond continue.
Thank you, Your Honor.
Let's call the case of the people versus Thomas Ellis.
For the addition on behalf of Mr. Ellis.
Mr. Ellis, can you unmute and state your name, please?
We can't hear you, Mr. Ellis.
There you go. I'm sorry about that. My name is Thomas Ellis.
Thank you, sir.
Good morning, Your Honor. We are going to be adjourning pending an update on sobriety court referral.
Has the referral already been sent?
Yes, Your Honor.
Probable cause conference then will be adjourned to the 22nd. Should be enough time to get information.
I believe so, Your Honor.
May 22nd. 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Mr. Ellis.
Yes, sir.
Court calls case People versus Haley Gregg. So,
Christina Costantino appearing on behalf of Haley Gregg. Ms. Gregg, can you please state your name for the record? Haley Gregg. Judge, today's the date and time set for a PCC. Obviously.
Okay.
I don't know why we always say that.
Yeah, it's okay.
It's
Always
habit.
good to have a reminder.
It's habit. There was an offer that was just recently tendered to us today. I would like an opportunity to discuss that with my client. If the court would consider adjourning the PCC 1 week, I think that would give us ample time. And I know that's a big ask, but she is in custody.
Yep, she is. May 15th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. Oh, Ms. Parody, you're here. Court calls the case People versus Mohammed Farah.
Assistant Public Defender Natalie Pate on behalf of Mr. Farha, who stands to my right. Please state your name for the record, sir.
Mohammed Farha.
Thank you, Your Honor. Mr. Farha has recently completed treatment at Sacred Heart. He does have some documentation of that, which he did show to us. He still needs to provide me some further documentation to provide to the people to potentially discuss a resolution of this case. We're requesting a 1 to 2 week adjournment, if Your Honor would allow.
That objection, May 22nd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case People versus Zachariah Haruska Dennis.
Jacob Kennedy for the.
Christina Costantino appearing on behalf of the defendant.
Morning, Your Honor. Mike Getty, Assistant Public Defender on behalf of Mr. Haruska Dennis in 25F5 5076FY.
Judge, I'm on the other case.
Yes.
Zachariah, could you please state your name for the record? Judge, with regards to my case, I was just appointed and I will need an opportunity to obtain discovery and review. It's the same with my client, so I would be asking for an adjournment.
Your Honor, in terms of the unarmed case, we'd ask for an adjournment to coincide with that. I have had some discussions with Mr. Haruska Dennis and with the prosecutor, maybe solve that.
May 22nd, 2025, 9 a.m. Bond will continue.
Your Honor.
Thank you very much, Judge.
Thank you.
Thank you.
Court calls case of the People versus Larry Holmes.
And then on behalf of the people, Your Honor.
And Your Honor, Alex Warren, Green on behalf of Mr. Holmes. Mr. Holmes, can you state your name?
Larry Holmes. Thank you.
Your Honor, today's the date and time for probable cause conference. At this time, we're asking the court to set the matter for preliminary exam.
All right. All the discovery is complete.
Believe so, Your Honor.
People have their witnesses available on the 20th. Preliminary examination set in person, May 20th, 2025, 9 a.m. before Judge Moore. Bond will continue. Thank you, sir. Court does call the case of the People versus John Coffey.
And this is the public. Your Honor, on behalf of Mr. John Coffey, was approaching. Mr. Coffey, could you say your name for the record once you get here?
John Joseph Coffey Jr.
Your Honor, we do have a resolution in this matter. The people have extended an offer. If Mr. Vannis can put the offer on the record for me, please.
same in each of the three cases. The forms you can see.
We should have had, but that's okay. I have. Everybody's right for now.
Yes, Your Honor. If the court wants to recall it, we can recall it and not have him. I did not have him sign this documentation previously. I apologize, Your Honor.
Well, he's out here now, so let's.
Okay.
We'll look it over. If he needs more time, then I'll send him back so he can have the time to do it.
Thank you, Judge.
Any-
Wasn't sure if
He'd be entering a guilty plea. Sign off, okay?
Yeah, just fresh caution. All right. So the court's understanding of the agreements are that he will be pleading to charges of retail fraud, an added count of retail fraud in the third degree, the 93-day misdemeanor. In all but, well, it will be count 2 in the cases ending in 1142 and in the case ending in 1576. It will be an added count 3 in case ending in 153. That is the court's full understanding.
That is our understanding as well, Your Honor.
All right, has he executed his advice right?
Yes, Your Honor, he has.
I haven't.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
John Joseph Coffey Jr.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to 3 counts of retail fraud in the third degree. Is that your understanding, sir?
Yes.
Okay, each of those counts is a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. Fine could be increased at 3 times the value of the property taken in each instance. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes, sir.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in these matters, and that you would be sentenced before Judge Freshour in the 14A3 District Court.
Yes, sir.
All right. In understanding that, you still wish to plead guilty?
Yes, sir.
All right. Starting in the case ending in 153, to that charge of retail fraud in the third degree. Hang on a second. What part? Oh, that is. I see that. Thank you. Starting in the case ending in 153. To the charge of retail fraud alleged to have occurred on the date of January 10th, 2024. How do you plead?
Guilty.
To the charge of retail fraud in case 1576, alleged to have occurred on the date of December 12th, 2023. How do you plead?
Guilty.
To that same charge contained in case 1142, alleged to have occurred on the date of May 8th, 2023. How do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of these offenses?
Yes, sir.
All right. Starting with the case ending in, I just gotta find my paperwork here. Case ending in 150153. On the date of January 10th, 2024, at the location of 5645 Jackson Road, Pittsfield, or in Scioto Township, Washington County, State of Michigan. What did you do at the Meyer store that makes you think that you're guilty?
Took merchandise that didn't belong to me.
Say again?
Stole merchandise that didn't belong to me.
When you say you stole it, you picked up merchandise and tried to walk out of the store without paying for it? All right, store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to take that property, did you?
No, sir.
And this property that you took, this was property that was offered for sale at Meyer?
Yes, sir.
Now to the case ending in 1576. On the date of December 12th, 2023, at that same location of 5645 Jackson Road in Scioto Township, Washington County, State of Michigan. On that date, what did you do at the Meyer store that makes you think that you're guilty?
Same thing. Tried to take things that didn't belong to me from the store.
Store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to take that property, did you? And this property that you tried to take was property that was offered for sale by Meyer?
Yes, sir.
Going to the last case ending in 1142. On the date of May 8, 2023, at the location of 3145 Ann Arbor Sling Road in Pittsfield Township, Washington County, State of Michigan. What did you do at the Meyer store on that location, and on that date that makes you think that you're guilty?
Take merchandise that didn't belong to me. Tried to.
The store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to take that property, did you? And this property you tried to take, this is property that was offered for sale by Meyer?
Yes, sir.
All right. Counsel, with respect to each one of these cases, has the court complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes.
Defense is satisfied as well.
In all of the cases, the court will accept the defendant's plea to the added count. In case 153, that would be the added count 3. Counts 1 and 2 are dismissed, and in the other matters, court will accept the defendant's plea to count 2. Count 1 is dismissed. In the cases ending in 153 and 1576, defendant is referred to probation for pre-sentence investigation and report at 1483. Probation sentencing in those matters will be June 2nd, 2025, 9 a.m. before Judge Fresh Hour. In those matters, bond will continue. In the other matter, defendant is referred to probation at the 1481 District Court. Sentencing in that matter will be May 28, 2025. That's 12 noon. That is before me.
Judge, can we address bond?
On all of these matters?
Yes,
go
sir,
ahead.
please. Your Honor, my client is asking that the court consider releasing him on a tether because he does have a home, a bed available at home with New Vision. He has been working with them. I don't have the documentation to provide to the court.
At home with New Vision for inpatient treatment?
That is correct, Your Honor.
Okay, go ahead.
So he's asking that he be allowed to at least start the program now prior to sentencing or the PSI being completed.
I don't have a problem with any release to inpatient treatment, but I mean, if you prepare an order,
sure,
I say all the time, indicating that he can be released on a PR to inpatient treatment, I don't have a problem and I will sign off on it.
Thank you, Your Honor. Okay.
But at this time, his bond will continue. Thank you. Court does call the case of the People versus Chad Jones. Pardon?
On behalf of Mr. Jones. I believe I stipulated to adjourn.
By yourself? How you do a stipulation by yourself?
I only see one on Judge Jones.
Oh,
One is
he-
adjourned, one
he-
is not.
that is correct.
Oh, sorry, I only see one on my,
There were two cases. You guys stipulated to adjourn one of them, but you didn't stipulate on the other case.
The other one is a different attorney.
okay.
Is
That's fine.
what?
It's a different attorney on the other job right now.
I rescind my appearance on the other case. I only see my name on there.
But you're on this one.
Yes, this is one we talked about.
Okay. Your Honor. We are going to.
No, it's okay. I'll wait. Welcome back up to the podium. Yeah, go ahead. What?
Give an audition on behalf of Mr. Jones for the second
You
time.
sure?
I am sure.
Okay.
Dang, I just removed his note. Okay. Your
You
Honor,
filed a green sheet. Are you asking for an adjournment?
we are asking for an adjournment.
So
pending
where's your
discovery.
client?
I told him we stipulated to adjourn and I didn't realize we were on the other case.
Your Honor, just for disclosure, there was a conversation where we talked about how there was two cases and one was adjourned. And the defense counsel thought they were only on the one case, and she said, I only did the one case since that's the only one we're on. So she's being very forthright and honest.
Thank you.
And saying she-
Oh, you're stepping up to vouch for her?
Thank you so much.
Is that what you're doing? No, I don't see this much, so I just trying to, I'm curious.
Officer of the court.
Thank you so much. Your Honor, this was my fault.
I know. Didn't have to say that. I mean, but that's you to fall on the story. So, gee, when did we adjourn the other one to?
I believe May 22nd. Let's see.
I just want to make sure that we don't put them on different days, because that would really confuse you, wouldn't it, Mr. Dudley?
I don't know. Apologies, Your Honor.
Okay. I will adjourn May 22nd, 2025, 9 a.m. Bond will continue even though he's not here, but that's only because she
Only
vouched.
because of my.
Otherwise, I would have been issuing bench warrants all over.
Thank you.
Thank you.
Court does call the case, People versus Richard Johnson.
Mr. Douglas.
Good morning, Your Honor. Assistant Public Defender Ben Denowith on behalf of Mr. Richard Johnson, who is standing to my right. Sir, would you state your name for the record?
I do, Your Honor. Richard Johnson.
Thank you.
Your Honor, today's the date and time for PCC. The defense would like exams on both of these matters.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available on the 20th. Preliminary examination will be set in person, May 20th, 2025, 9 a.m. before Judge R.
Come talk to you.
Bond will continue.
17:30.
He's working.
What if
Working.
we don't work?
Court calls the case, People versus Quincy Jones. Sure. Quincy Jones. Thank you, sir. What's your, all right.
Your Honor, we are asking for an adjournment. This charge was a pending, there was another charge that was pending reauthorization. I believe prosecution is getting closer to that. And we are going to be asking for an adjournment for potential resolution with the prosecutor.
Is that right?
My understanding is swear to.
So it's been sworn to, but no arraignment as of yet?
No, it's not been sworn to.
It has not been sworn to. Do we know when that's going to happen? So we could try to time this out if I'm turning it to that.
Best I can say at the moment, I will contact the officer right after court today. I don't know when that.
I'll adjourn this into May 29th, 2025, 9 a.m. Hopefully catch up by that point in time. All right,
Thank you.
Bond will continue on this one. Okay. Or does call the case of the people versus Aaron McCollum.
And Alex Warren Green on behalf of Mr. McCollum. Mr. McCollum, can you please state your name for the court?
My name is Aaron McCollum.
Your Honor, today's the date and time for a competency restoration review. Yes, and Your Honor, I have no further information from the forensic center. I'm not sure if the people or the court do.
I have, you mean other than the April 17th?
I am not in receipt of that.
You're not in receipt of the April 17th?
Not personally. It may very well have been sent to our office.
People received it and saw that he was still not competent.
Right. But you need to at least review that and go through that with your client.
And Your Honor, if that's the finding, I'd stipulate to that finding.
You'd stipulate to that finding?
Yes, Your Honor.
Okay. All right. Based upon that, the defendant still remains incompetent, but likely to obtain competence with and is restorable. So I'll continue that order. I'll set a competency review hearing in this matter. Yeah, we might as well do 90. If they send it sooner, then we're good.
August 7th at 9 a.m.
August 7th, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue in these cases. Thank you, sir. Court does call the case of the people versus Montez King.
Michael Gaddy, Assistant Public Defender on behalf of Mr. King, who's here to my right. State your name, Mr. King.
Montez King.
And I do have a green sheet. I have had a chance to speak about this matter with Ms. Willenbring. There's, I think we've executed an order for, which I think has been submitted to Your Honor, for the release of some forensic video. And also, it's my understanding there's some more discovery that pending from a search warrant that was issued that we're looking to obtain. So I'd ask the court to adjourn this matter to allow us to.
All right, I've signed the protective order in this case. How much time are you going to need to?
Based on what I read in the police report, once we get the video, I don't think it's going to be very long to review. I don't know what's in the search warrant. I don't even have the tab yet.
Got it.
We'll get the release today.
May 22nd, 2025, 9 a.m.
Thank you.
I'm sorry, I didn't catch that date, Judge.
22nd.
Thank you, Judge.
Bond continued. Court does call the case of the people versus Stephen Bernard Moss Jr.
Alexander on behalf of the people, Your Honor.
Assistant Public Defender Ben Dunawith on behalf of Mr. Moss, who is standing to my right. Mr. Moss, would you state your name for the record?
Stephen Moss.
Yes, sir.
Your Honor, today is the date and time for a PCC. The defense will demand exam at this time.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available on the 20th.
We'll do our best, Your Honor, and I believe the 911 call has been requested today, so I don't think we have that yet.
I'll indicate that with the exception of that one, discovery is complete. Preliminary examination will be set May 20th, 2025, 9 a.m. That is before Judge Moore. Bond continued.
Thank you. Court calls the case of the people versus Alante Lindsay.
Allie Zen on behalf of the people, Your Honor.
Your Honor, Alex Warren Green, Mr. Lindsay.
Sorry, didn't mean to surprise you. Go ahead.
Your Honor.
Your Honor, maybe briefly approach.
Sure. Why's everybody looking back there?
For Mr. Lindsay, Your Honor.
Oh, okay.
Yeah.
All right, record should reflect we've got a bench conference in this case. Alante Lindsay, there's no response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $50,000. Cash surety. That warrant will issue immediately. Thank you.
Thank you, Your Honor.
Court does call the case people versus Richard Hall.
Allie Zen on behalf of the people.
Good morning, Judge. Christopher Quinn appearing on behalf of Mr. Hall.
Yes.
Mr. Hall is requesting an exam, but I need it, if available, June 3rd. I have 2 trials back to back.
The discovery is complete.
Yes, Judge.
With the people, is he being held on anything else?
No.
Your Honor, he has a hold out of Oakland with his bond denied for a VOP for his 83rd.
In Oakland, so he wouldn't go anywhere anyway. All right. People have their witnesses available June 3rd.
We'll do our best, Your Honor.
Preliminary examination in person, June 3rd, 2025, 9 a.m. before Judge Perry. Bond looking. Court calls the case of the people versus Marcus. Is it Bial?
Allie Zen on behalf of the people, Your Honor.
Good morning, Judge. Christopher Quinn appearing on behalf of Mr. Beal. Bale.
State your name again, sir.
Marcus Bill.
Okay.
We're requesting an exam as well, Judge. So for the 3rd, if possible, Judge Perry.
Well, you get to pick your judge. You usually don't get to pick your day. Discovery is complete on this.
Yes, Judge.
People have their witnesses available the 3rd.
We'll do our best, Your Honor.
Preliminary examination in person will be set June 3rd, 2025, 9 a.m. before. Before me.
Oh,
Bond will continue.
okay.
Court calls the case of the people versus Bruce Pickens.
People. Warren Green on behalf of Mr. Pickens. Mr. Pickens, can you state your name for the court?
Bruce Pickens.
Your Honor, I have 2 green sheets here, 1 for each case. We're asking for an adjournment in both. We recently made a referral to our social work division. They are completing a mitigation report for the people's consideration, and I believe also the court's consideration, so we can make an informed bond argument at the appropriate time.
Probable cause conference will be adjourned to May 29th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Calls case of the people versus Jeffrey McCullough.
Morning, Judge. Christopher Quinn appearing on behalf of Mr. McCullough. He's on Zoom, I believe.
Ken Medadish also on behalf of Mr. McCullough.
You have it? McCullough? I don't have it.
I'm gonna call him, Your Honor.
Right now? Oh, go ahead. We'll wait. Did he?
Yeah, but.
iPhone 1. Can you tell us your name?
He said he's on there. He doesn't know how to unmute it. Did you dial in or are you appearing?
What? Oh, okay.
Okay,
Go ahead.
can you
Have the
call
whole
out?
conversation. What's the name that appears on his screen?
What is the name that appears on? Samsung.
Okay, I see him. He's got his hand raised. He doesn't know how to unmute.
Okay. Do you see an unmute button? Your Honor, I'm thinking of telling him to leave the Zoom and join again. Is that okay?
What? You told him to leave?
I know, I'm thinking to tell him that because he said it's.
No,
he's
well,
unable to.
hold on. He's unable to what?
To unmute. He's trying to click it. That's why I'm trying to ask him to leave the Zoom and come back.
Okay, fine. I'll pass it.
Thank you, Your Honor.
Yeah. I was gonna say that when I said that. Court calls the case, People versus Robert Connolly.
Jacob Kennedy, on behalf of the people, Your Honor.
Morning, Robert J. Cool on behalf of Mr. Connolly. Robert, would you say your name for the record?
Robert Connolly.
Judge, I was just appointed these 4 matters. I spoke with Robert last night at the jail. He understands that I need to get the discovery and forensic interviews, so I'm asking for a 2-week adjournment.
2 week.
Is that enough time to get the?
Yes. We'll get.
Probable cause conference will be adjourned May 22nd.
I'm sorry, Judge?
May 22nd.
I can ask I'll come back.
That work?
I'm sure it does.
All right, May 22nd, 2025, 9 a.m. Bond will continue on these matters.
Thanks, Judge.
Does it make all of them look funny? You said, oh, same thing.
Yeah, he has a name right now. He went away. He left. He was on.
Okay, all right, thanks.
He's unmuted.
Yeah, he
Sure. And then he.
left.
Court. I don't know what that's about. Court does call the case of the People versus Lauren Michaels.
Good morning, Your Honor. May it please the court, my name is Matt Savage. I represent Ms. Michaels. Judge, I'm going to ask the court to waive her presence this morning. She is in Trinity Hospital. She was an involuntary commitment there, which is her second involuntary commitment to a hospital in the last, since the last hearing, which was the PCC back over 30 days ago. I know she has a bond violation up, but I think she was actually in Battle Creek. I forget the name of the facility. I want to say it was called Buchanan, but I'm unfamiliar with that facility. And then she was released and then recommitted, and now she's in Trinity, which is the old St. Joseph's Hospital in Ypsilanti. Judge, I did have her independently evaluated. She does have some significant mental health issues. I'm desperately trying to get things together so I could submit a deviation request and also try to get her into the mental health court.
She was. Okay, just so you know, my staff has indicated your client did sign in, it looks like with a social worker, but somehow or another then logged out.
I'm right here.
Yes,
Oh,
Your
hold
Honor.
it. You're right there.
Yeah.
That's not the one.
Technical difficulties.
No, that's the other case, Judge. My client is doesn't.
That's not Miss Michael's case.
No, that's
All
not.
right. No, I know that's not her. 'Cause all right. So what are you requesting, counsel?
Judge, if we can put this PCC off another 30 days, I'm hoping that I'll have at least spoke to the prosecutor's office about trying to work out a plea deal and also get her into the mental health treatment court. I think she's a perfect candidate for it. I don't know what other reasons why we would have a mental health court, but for people like Ms. Michaels.
Do people have a position on this?
I mean, Your Honor, in 30 days, she very well might still be in the hospital. I know that there was the updated violation report.
I know.
And so I don't know if adjourning this is moving it forward or not.
Well, it's not necessarily. I mean, there are significant issues which the court was apprised of at the last hearing, which is why I said it in part for a bond hearing today.
But I think
go ahead.
I think things are a little bit worse than I presented to the court in chambers last time.
Yeah. I would agree, but it was, I guess the best way to put it, we were being apprised of certain things that were being said at community corrections.
Right.
It seemed to the court when I would be apprised of them, I'll put it gently, that she was on a downward spiral from where she was when she was here. And it does not surprise me that we're at the point that we're at right now at all. So here's what I will do. Because we don't know how long she'll be in Trinity at this point.
I spoke to the social worker yesterday. She did grant, my client did grant her permission to speak to me. It looks like they're doing another evaluation, but also my client has agreed to voluntarily stay regardless of what their decision is. And she's also agreed to finally get treatment. She's been very reluctant for a while. So that's a positive thing. And I'm hoping that it continues to stay positive in that direction.
Okay, I'm not going to adjourn it quite out 30 days. So what I'm going to do is I'm going to adjourn this to May 22nd, 2025, 9 a.m. Let you guys get at least an update as to where she is. Okay. And part of my reason for doing that is because I know she's in agreement at this point, but it kind of changes with her. So, but then if what parties do leading up to this date on the 22nd, if the party want to stipulate to another 2 weeks out, then I'm not going to have a problem with that.
Okay.
Okay, but at least we'll keep a look on it.
Thank
Okay.
you.
Bond will continue. Thank you, sir.
Bye-bye.
Court does call the case of People versus Joel Stevens.
On behalf of Mr. Stevens.
Joel Stevens.
All right, and what are we doing on this case?
Your Honor, we're asking for one more adjournment for potential offer from prosecutors.
Potential offer, well, I don't know what that means.
We're working on an offer. I believe the officers need to be contacted on this case.
How much time are we going to need for this potential offer?
1 week.
Probable cause conference, May 15th, 2025. 9 a.m. Bond continue.
All right. Your Honor, can I please ask for a bond to be revoked? That way I can get this resolved before the MDOC comes and gets me.
Excuse me?
Can I ask for this bond to be revoked or $100 bond or any type of bond at all? That way I can get this case resolved before MDOC comes and gets me.
I don't. What's his bond currently? Pardon? I have his bond at 1,000 cash surety. Well, yeah, right.
Any bond.
It what? Got it. So, counsel, what do you want me to do?
Your Honor, can for bond to be revoked on this case?
You sure can.
I'm not.
I don't have a problem doing that. It's just a box here. And I say the words. But I don't know if that's what you really want me to do.
My fiance posted my bond. I'm just trying to make sure that.
Your Honor, can we ask for an increase in bond?
Sure. You guys decide. What I'll do is I'll do a 10,000. Well, counsel approach first. All right, what I will do in this case is I will set the defendant's bond at 10,000 cash surety at this juncture. And we'll see you on the 15th. Thank you. Court calls case People versus Brandon Clement.
Good morning, Your Honor. J. Latif, BAIG, P 36820. Appearing on behalf of Mr. Clement and his attorney, William Amadio. He asked me to step in today. State your name for the record.
Brian J. Clement.
All right. What are we doing?
All right, well, today's the day for a probable cause conference. At this time, Your Honor, I'm going to ask for a 30-day adjournment for mitigation purposes. Mr. Clement we're going to have him assessed, and currently he's also attending AA. We requested
get him assessed.
About 30 days, if Your Honor would so order.
So is it going to take him 30 days to get him assessed? I guess that's what I'm.
That was his first opening to see me. The guy that getting my assessment.
I'm sorry.
That was his first opening to see me. Was his just get the assessment.
Any response from the people?
Your Honor, right now, there's not an offer given the history and the allegations, and I did say to the counsel that if there was an offer, it would depend on what documentation they could provide as far as treatment plans. So,
Got it. I see. Okay. Is he on a tether?
I have a sober link.
You have a sober link? Okay. All right, I'll adjourn it to June 5th.
9 o'clock?
June 5th, 2025, 9 a.m. or as your invite indicates. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case People versus Troy Swope.
The defendant shall be hearing Kimberly on behalf of Mr. Troy Swopes. Mr. Swope, state your name for the record, please.
Troy Swope.
So, Your Honor, we are requesting that this matter be set for preliminary examination. I know the court is going to ask us if discovery is complete. We do not have.
Gee, really?
Yeah.
You know that.
You know, we do not have the video in this matter yet. However, this case has been going on for quite some time now. If the court is aware, Mr. Swope was remanded at his last hearing due to a community corrections violation. Ms. Douglas states that she's working on trying to see if there is video to even submit. I really do not want to just adjourn this matter out and then.
Okay, that's fine, but if you get to exam and the video comes in and you have a problem with the video or the like, or think that you're not going to get an adjournment because you don't have it.
I understand that, Your Honor.
You understand that, Mr. Swope?
Yes, Your Honor.
Action will be set. Would everybody be ready to go on the 20th? May 20th, 2025. 9 a.m. That's before Judge Moore. Bond will continue.
Thank you, Your Honor. Okay, I'm gonna.
Court calls case People versus Jeffrey Moore.
Oh, Andrew Bannis for the people, excuse me.
But he may not go.
Assistant Public Defender Ben Benoith on behalf of Mr. Moore, who is standing to my right. Would you state your name for the record, sir?
Jeffrey Moore.
All right, what are we doing?
And Mr. Moore, we're going to set this for exam, right?
Yeah.
And we'd like an exam, Your Honor.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 20th.
We'll do our best, Jim.
Preliminary examination, May 20th, 2025, 9 a.m. It's in person before Judge Barr. Bond will continue. Thank you.
Thank you.
Court calls case of the People versus Megan Moses.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Moses. Ms. Moses, please state your name for the record.
Megan Moses.
Thank you.
Your Honor, we're here for a PCC. We are asking.
Why does it keep telling me?
It gives me a second to like get my brain to catch up.
I know everybody keeps telling me.
Your Honor, we're requesting an adjournment. I did speak with Mr. Banis and there has been an offer made. I just would like some more time to speak with Ms. Moses regarding that offer. And I'd also like to address bond. I don't want you to lock her up, Your Honor. I said, I don't want you to lock her up, Your Honor.
Really?
But she, really.
Okay.
But she is on a tether. She was released from Washington County Jail on a GPS tether. We are asking for the removal of that tether. Ms. Moses was in custody here for 25 days. Now that she's released, she's trying to get back to work. This is a large financial burden on her, as well as she's trying to pay the restitution on this case. I did speak with Mr. Banis and he doesn't have an objection to it being removed. So that is my request today of the court.
Why was it put on in the first place?
I believe she failed to appear at a PCC.
I did
And
request. Oh, sorry.
I'm thinking of what she may be saying is that she was, when she failed to appear, she did try to get in touch with our office and was living in Jackson without transportation here. She was unable to get in touch for a Zoom request. And then was, I believe, were you picked up or did you turn yourself in, Ms. Moses?
I was picked up.
And then was here for 25 days and then.
Why was she picked up?
I don't.
I was picked up in Jackson County. That's where I live. And then transported.
What, they just came and got you?
No, I took care of the count here. It was a retail fraud here in Jackson.
Sure, I'm understanding. What, you went to court in Jackson County, had the warrant here, and they took you into custody?
Correct.
Oh. Okay.
So she's coming to court, Your Honor. And she's here today.
I also am using a bike for transportation, and it's really hard to get around without having or with having it on. It's hard in general. I'm not trying to avoid or not have accountability for what I need to. I honestly am just doing my best.
I put her on GPS just this past month or in April.
Yes.
Right?
Yes.
That was after modifying her bond.
Right.
Yes.
The bond, I was here I went to Washtenaw County originally, and They gave me a court date for which I was not able to obtain a Zoom for or get a ride to. Now that I am able to get the Zoom, I am able to make it. And also I have transportation where I have support and people who can take me to and from if I need to make a physical appearance.
Said there is likely to be a resolution. So what I'll do is I'll move it up a week. I'll set this for the 15th. You guys figure it out. I'm not gonna change the bond condition. I'll leave the GPS in place, but I move it up a week.
Thank you.
All right. Thank you.
Okay, thank you.
I thought it did. Yeah, the 15th.
Okay, thank you.
Court calls the case People versus Jeffrey McCullough.
Andrew Bennett.
The recall.
Mr. Quinn, appear number, call it.
Kevin, also on behalf of Sir Call on the case ending in 5631.
Jeff McCullough, Your Honor.
McCullough,
Sorry
can you state your name, please?
Jeff McCullough, sorry about the technical difficulty.
No, it's okay. It's okay. It's Mr. Lucius' fault. All right. All right. What are we doing?
Your Honor, on my case, there is an offer by prosecution to plead to count 2, dismiss count 1, and we are going to be taking that offer today.
On the 5631 case?
Yes, Your Honor, and I have the.
What are we doing on the other case?
We're just gonna need another day to get, need a modification of our offer. And the prosecutor is going to look into whether he can modify our offer. There's,
On that case, Your Honor, our office made an offer. Counsel has, the counselor offer, I told him, can't do that today, but possibly if there's an adjournment.
Probable cause conference in that matter then will be May 22nd, 2025, 9 a.m. Bond will continue in that case.
And I want to state, Your Honor, I did sign it with his permission and wanted him to state on the record.
That you signed the advice of rights with his permission.
Yes, Your Honor.
And went through it with him.
Yes, Your Honor.
All right. Mr. McCullough, can you raise your right hand, please, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again for the record, please, sir.
Jeff McCullough.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of disorderly person. Is that correct?
Yes.
That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You had given permission to sign an advice of rights form, is that correct?
That's correct.
Do you have any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form if you have a copy. You
Okay.
understand that under paragraph 5, those are your rights which are part of a trial. You understand you're waiving or giving up those rights.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes, sir.
Because you believe that you're guilty of this offense?
Yes, Your Honor.
October 13, 2022, at the location of the 300 block of East William Street, City of Ann Arbor, Washtenaw County, State of Michigan. What happened that makes you think that you were a disorderly person on that day?
I was intoxicated on I was intoxicated in that area of not complying with the law enforcement.
Say that last part again.
I was intoxicated in that area, not complying with law enforcement.
Okay. And I guess we can do it this way. And in being intoxicated in the way that you were acting, you endangered or put in jeopardy property of others and or
Yes,
other
Your Honor.
persons?
Yes, Your Honor.
All right. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
People are satisfied, thank you.
Defense is so satisfied, Your Honor. Thank you.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be June 6, 2025, 8:30 before Judge Perry. Bond will continue.
Thank you.
Thank you.
Your Honor.
Court does call the case, People versus Emily Bates.
Assistant Public Defender Natalie Pable on behalf of Ms. Bates, who appears via Zoom. Ma'am, can you please unmute and state your name for the record?
Hello, I'm Emily Bates. Good morning.
Thank you.
Thank you. Oh, sorry, Your Honor. Thank you, Your Honor. I'm standing in for Ms. Perny. It is my understanding that Ms. Bates recently underwent a substance use as well as a mental health assessment, and she would like to get that documentation to our office to provide to the people. So we'd be requesting an adjournment for that to happen.
I need a green sheet, but without objection, May 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Bond continue. Thank you. Court does call the case, People versus Ryan Lee Patterson.
Alex Warren Green on behalf of Mr. Patterson. State your name, Ryan.
Ryan Lee Patterson.
Your Honor, I executed a green sheet in this matter. I'm asking for an adjournment as long as the court can accommodate. I spoke with Mr. Ward. There's some discovery exchange that needs to take place. We want to negotiate and to make sure everything's squared away before we move forward on this matter.
That's correct, Your Honor. Mr. Warren Green did reach out to me. There are some questions he has regarding the autopsy in this case. I am going to assist in a possible meeting with the medical examiner.
How long is that going to take you? You're going to move this along.
Your Honor, I know you don't like me picking dates.
You're right, but you're about to try to do that, aren't you?
Can I give you 2 dates? Your Honor, I think by June 2nd, we'd have done what we need to have done.
Probable cause conference, June 5th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. Yeah.
Thank you.
Thank you, Your Honor.
Court does call the case, People versus Carlos Payne.
Haley said on behalf of the people, Your Honor.
And Alex Warren Green on behalf of Payne. Mr. Payne, can you unmute yourself?
Carlos
and
Payne here.
state your name?
Good morning.
Thank you.
My name is Carlos.
Thank you.
Your Honor, in one of these cases, we are awaiting some outstanding media discovery. I'm asking for an adjournment in both so that we can receive that.
Is there something unique or you're just waiting on it?
I don't believe there's anything unique. In the case ending 0395, we just do not have the body worn camera discovery.
May 22nd, 2025, 9 a.m. on both matters.
Thank you, Your Honor.
Bond continue.
Your Honor.
Have a great day.
You do the same, sir.
Your Honor, I do have green sheets.
Oh, thanks.
Thank you very much.
Court does call the case of the people versus Marilla Philpott. Marika.
Assistant Public Defender Natalie Pate on behalf of, but I do not believe with Ms. Philpott. Your Honor, we do not have an explanation for her failure. Would respectfully request an adjournment for the record.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000 as surety. That warrant will issue immediately.
Thank you, Your Honor.
Thank you.
Thank you.
Court does call the case people versus Tyler Pittman.
People?
I have another issue with and on behalf of Mr. Pittman. Can you say anything for that?
Tyler Pittman. All right, you're looking for an adjournment for mitigation purposes.
Yes, Your Honor, and to continue plea negotiations with.
May 29, 2025, 9 a.m. bond continue.
Have a good day, sir.
All right. That's called the case of the people versus Cynthia Suttle.
Andrew Banish for the people.
Your Honor, can I run to Judge Perry's courtroom to grab Ms. Perry really quickly? I apologize. I think I can step in, Your Honor. I apologize.
Assistant Public Defender Natalie Pate standing in for Ms. Perry for Ms. Suttle, who should be present via Zoom. Ma'am, can you please unmute and state your name for the record?
I should be unmuted. Is it unmuted?
Oh, yes,
You're
we can hear you.
unmuted.
Thank you.
Okay.
Cynthia Suttle.
All right, thank you. I have before me a plea form. Is that what we're doing?
Yes, Your Honor, that is my understanding.
Okay.
I didn't really. All the restitution in advance.
Plea form indicates that the defendant will be pleading guilty to 2 misdemeanor charges, added counts 5 and 6. Count 5 being larceny 200, but less than, greater than 200 to 1,000, I should say, the 1-year offense. And account 6 of larceny less than 200 to 93-day offense. Upon a successful guilty plea to those charges, counts 1 through 4 would be dismissed. There is also a confirmed restitution. I'm presuming that
Paid in full.
restitution of $2,800, which has been paid in full, and it's being held by the court as bond to be applied to restitution. That's the court's full understanding of the agreement.
I believe that is what was discussed with Ms. Suttle, with Ms. Perry, and we are proceeding today. Thank you.
So is that?
That is our understanding.
Is that your understanding of the agreement?
Yes, Your Honor, it is.
Ma'am, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes.
All right, state your name again for the record, please.
Cynthia Suttle.
All right, ma'am, it is this court's understanding that you are going to be pleading guilty to 2 misdemeanor charges. The first charge is that of larceny 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, I do, Your Honor.
And also an added count 6 of larceny less than 200. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand all of that?
Yes, Your Honor.
You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
I understand.
All right. Still wish to plead guilty to these charges?
I do.
To the charge of larceny, 200 to 1,000, how do you plead?
Guilty.
To the charge of larceny less than 200, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
I understand.
You signed or gave permission to sign an advice of rights form, is that correct?
Yes.
All right. Do you have any questions regarding any of those rights?
I don't.
All right. Under paragraph 5 of your rights, which are part of a trial, you understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
I understand.
You understand you're giving up your right to appeal of right.
I understand.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes, Your Honor.
and also because you believe that you're guilty of this offense,
Yes, Your Honor.
of these offenses. On December 2nd, 2023, at the location of 3131 South State Street, City of Ann Arbor, Washington County, State of Michigan, what did you do on that date that makes you think that you're guilty of these offenses?
I took a credit card without permission.
Okay, you took a credit card without permission with the intent to use it?
Yes, Your Honor.
Did you use it?
Yes, I did.
All right. Was the amount that you received of using that credit card without permission, did you receive in goods or services an amount greater than $200?
Yes, Your Honor.
Did you use it on more than one occasion?
Yes, Your Honor.
All right. And on the other occasion, did you receive goods or services in excess of $200?
No. No, Your Honor.
Okay. But you used it on 2 occasions, correct?
Yes, I did, Your Honor.
All right. And on one occasion, you received an amount in excess of $200.
Yes.
All right. Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to counts 5 and 6. Counts 1 through 4 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
June 3rd at 9 a.m. before Judge Belvo.
June 3rd, 2025, 9 a.m. before Judge Valvo. Bond
Thank
will
you.
continue.
Thank you, Your Honor.
Thank you, Mayor.
Thank you, Your
Thank
Honor.
you.
Thank you, Ms. Tuttle.
Thank you, Lauren.
And doing.
Your Honor,
No. No. You're about to start something. Court calls the case People versus DeMarcus Thompson.
and for others for the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Thompson, who is not present, Your Honor.
He is not.
He is not. Mr. Thompson is in the Macomb County Jail. He is, looks like he was, he was reported to turn himself, I'm sorry?
He's in Macomb.
Macomb, yes.
Okay.
It was since May 3rd. Per Vine Link, his out date is May 30th. And it looks like it's an old VOP case. I'd ask the court to adjourn this matter to any date after May 30th to ensure his presence. I have prepared a green sheet.
Probable cause conference in that instance. Court will find due cause. I will adjourn it to June 3rd, 2025, 9 a.m. Bond continues.
Thank you, man.
Case People versus Roman Whitfield.
And for others for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Whitfield, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Roman Whitfield.
Your Honor, the people have extended an offer in this matter yesterday afternoon that I do still need to discuss further with my client. I would be requesting a brief adjournment for that purpose.
That objection, May 22nd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Thank you, Mr. Whitfield. You're all set for today. I'll be in touch.
Thank you, sir. Really? Amazing. You got through it. Hold it. Isn't that their intern? She's on the wrong side again. Why is she on that? That's okay. I'm gonna leave it alone. Court stands in recess.
Oh. 2 days in a row.
Is there some excuses form on the website?
Yeah, and then
So you gotta watch this one. All right. 14A District Court for County of Washington, State of Michigan is now back in session. The honorable Judge Simpson.
You may be seated. Is it?
Yep.
Thank you for what?
Remembering to bring it.
Oh, yeah. I kept thinking if I bring it in and, well, whatever.
Each and copy different.
Are our attorneys? They still are?
Yeah.
Okay. Court does call the case of the people versus Nicholas Shaffey.
Your camera's not on.
Haley Zend on behalf of the people, Your Honor.
Joe Simon on behalf of Mr. Chafee, Your Honor, I'm going to have him execute a couple of forms that I've already reviewed with him. Rights form, you need to sign that. This is the sentencing the form that we discussed, you signed there. Thank you. There we go.
Your name, sir?
Nicholas Chafee.
All right. Court has before it a plea form that states that the defendant is going to be pleading of the charge of aggravated domestic violence to 1-year offense. On his successful plea to that charge, counts 1 and 2 would be dismissed. There's also agreement between the parties to no upfront jail, recognizing that this court cannot bind the sentencing judge in this matter.
I've explained that all to my client.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Nicholas Chafee.
All right, sir, it is this court's understanding that you're going to plead no contest to the charge of aggravated domestic violence.
Yes, sir.
That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. Do you understand that?
I do, Your Honor.
All right. Do you understand what a no contest plea is?
I do, Your Honor.
All right. 2 things about a no contest plea I have to make sure that you understand. The first thing is that you have to understand that it means that you're not further desirous or wanting to contest this charge. Do you understand that?
I do.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you would have pled guilty. You understand that?
I do, Your Honor.
And you understand, sir, that also while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Perry in 15th District Court.
I understand that, Your Honor.
All right. Basis for no contest plea.
Intoxication, Your Honor.
All right. So, sir, to that charge, how do you plead?
No contest, Your Honor.
All right. Now you understand that by pleading no contest, you will not have a trial of any kind.
I do.
You signed an advice of rights form. Is that correct?
I did, Your Honor.
Any question regarding any of those rights?
No questions.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
I am not, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
I am.
and of your own free will?
I am.
All right. The court has been provided and has reviewed Ann Arbor Police Department report for their case number 25-13270. Any objections to the court having reviewed that report?
None from the people, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this defense counsel. Have I complied with the court rule?
Yes, Your Honor, people are satisfied.
Yes, Your Honor.
Court will accept the defendant's no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
May 28th at 9 a.m. for Judge Perry.
May 28, 2025, at 9 a.m.
Yes, sir.
9 a.m. before Judge Perry.
Your Honor, may counsel approach real quickly? Sorry.
Ms. Zendicamp. Yes, you may. Record should reflect we had a bench conference in this case. The sentencing date will be May 14, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue.
Thank you.
Thank you. Court calls the case, People versus Stephen Smith.
APA Rachel McDonough for the people on all 4 cases.
James Fifelsky appearing on behalf of Mr. Smith on case ending with 5506. This is the one. We have another attorney on this. I'm not sure where she is.
Who's on it?
Thanks. They're going to try to find her right now.
Ernie. You can actually do it, Mike, because they're gonna have to be adjourned.
Mike Getty, Assistant Public Defender on behalf of the defendant, Your Honor. Mr.
The
Smith.
court received information that this gentleman was in Monroe County. The writ was done to get him here from there. However, in the interim, he was transferred, I think, to Jackson County. So he was not picked up and won't be here.
Okay.
All
A
right.
lot of construction, Judge.
All right. So was this originally mine?
Yes.
Okay, so my next date is. That we won't have enough time. All right. So preliminary examination, the court will find good cause. I'll adjourn it in person to June 3rd, 2025, 9 a.m. That's before me.
Thank you, Your Honor.
Your witness.
And his bond will continue.
Thank you very much, Your Honor.
All right, thank you.
What time did you say? What time did you say? 12 o'clock?
Really? What time do I always say?
12 noon. That's what it was today.
God sakes, Fifelsky.
9 o'clock. That's the
Yes, it's
second.
9 o'clock.
Okay,
I'll put you
okay.
into a block. Really late into the day and maybe into the evening going into
It's
you.
been a long day already, Judge.
What?
It's been a long day already.
You don't even know the half of it. All right. Court does call the case of the People versus Devon Gibson. 2 cases.
Ally Zend on behalf of the people.
Yes, Your Honor, we please present before Brandon Bird on behalf of Devon Gibson. Mr. Gibson, can you please state your full name for the record?
David Gibson.
Your Honor, may we approach?
You may. Yes. All right, record should reflect we had a bench conference in this case, and my understanding, well, there are numerous calls that council has not had an opportunity to hear yet. There's also going to be a motion to proceed by forfeiture, which the prosecutor is going to file, but without hearing the calls, it becomes a bit difficult to try to respond to some of that. So what we've come up with is I will adjourn, with the defendant being in custody, I'll adjourn this just 1 week out to the 13th, to May 13th at 9 a.m. That'll be before me. I also told council that as long as I receive the response to the motion by the 12th, I'll be prepared to go on the 13th regarding that. So I'll adjourn it out to that date. Bond will continue, I believe, as for the vote.
Thank you, Your Honor.
All right, thank you. That's called the case of the people versus LaDonda Skinner.
Haley said on behalf of the people, Your Honor.
For the judge, Commissioner, please, Assistant Public Defender on behalf of, but not with Mr. Skinner.
Show up today, you don't have a client.
I unfortunately, that is the case. Yes.
Okay. So he already has a failure to comply bench warrant out, so. What is that? Is that a no bound?
Yes, sir.
All right. So what I will do is I can do it one or two ways. I'll just issue a bench warrant. I'll just leave that bench warrant, leave that outstanding.
Thank you, Judge.
Thank you, Your Honor.
All right, thank you. Case people versus Sadie.
Haley said on behalf of the people, Your Honor.
Your Honor, Michael Vincent on behalf of Sadie Fodderall, who is approaching.
She's right there.
Vincent, just go to the side you normally are supposed to be on.
I'm dancing, Your Honor.
Not very well, but go ahead.
I tried though.
Yes.
I can make another comment, but I'm not going to.
No, I'm glad. All right.
Your Honor, maybe approach.
Give me one of those days. Sure, come on.
Your Honor, today's the date and time set for preliminary examination. At this time, the people are unable to proceed as to count one. I would ask that count two be remanded to 14B District Court.
I will continue the plea of not guilty as to count two. I'll set a pretrial in that matter, 14B for June 16th.
Yes.
June 16th, 2025, 10 a.m. That's before Judge Washington.
Your Honor, may we address bond?
You may.
My understanding that the gentleman involved in this case would like contact.
And that's correct, Your Honor. He is here and would like to address the court.
Why don't you?
All right. No, you'll have to over that. Sorry, sir. Afternoon. What's your name?
Brian Busick.
Okay. What do you want to tell me?
I would like to remove the no contact order so we can possibly work on coming back as a family, and I miss seeing my kids every day and all that. Kind of at a loss of words for it.
Pardon?
Kind of at a loss of words for this. Just the fact that I would like the no contact order removed, if that's possible.
And there are two children involved?
Yes.
Okay. All right. Thank you.
Thank you.
Benson, do you, ma'am, you can. You don't have an objection to that?
No, Your Honor.
Do is I will delete the no contact provision. I just want to double check and make sure. Well, I don't. Well, let me ask this. Are they requesting contact other than just parenting issues?
He is here.
Because that's already, when I look at this, that's already in place. So it's only consensual contact for parenting issues.
I think the request is more than that from my client's understanding. She's living with his mother right now, her mother.
Pardon?
My client's living with her mother on Hemp Hill. The family home is on Bagley. They got two little kids. And I believe the father, who you just saw, is working and trying to handle the two little kids. I think there's an effort by this couple to try and put things together. That's how I read what.
Is that right, ma'am?
Yes.
So the way that I'll do this is I will delete the, I guess, really the consensual contact provision. Provision for, yeah, I'll delete the consensual contact for parenting. And then I will add no non-consensual contact for any reason. So what that means, ma'am, if for whatever reason he doesn't wish you around him, then you need to leave the area. You understand that?
Yes, I do.
All right. In all other respects, bond will continue.
Thank you, Your Honor.
Calls the case, People versus Dominique White.
Ally's on behalf of the people, Your Honor.
Was you doing something?
I did.
Did you? Oh, okay, no, my bad. Oh, I see it.
That is on behalf of Mr. White. Can you state your name for the record?
Dominique White, Your Honor.
All right, thank you. What are we doing?
Your Honor, today's the day for preliminary examination. At this time, I would be asking the court to add a count 2 of domestic violence second offense with the PAC code 750.813. And people would be unable to proceed as count 1, ask that count 2 be remanded to district court.
Okay, so part of that's going to be a bit of a problem in doing that this way. We did it before. I did it before. And theoretically, I would need a new complaint with that charge on it. I don't mind sending the defendant. Can you get that done quickly?
Yes.
Okay, so what I'll do is let me pass the matter, get that done so that I have that complaint before me. Is there going to be any objection to the adding of that charge?
No, Your Honor.
All right. Okay, so then we can do that so that he can properly know what the charges are.
Okay.
Because, all right.
So, okay.
The next one, is this one also in custody?
Is it custody?
But not on here.
Correct, back here.
Okay, are they bringing him right back up?
No.
No? Okay. Then I'll do this one. Court does call the case People versus Antonio Cornelius.
Yes, Your Honor. I think this is Mr. Ward's case.
Marie Tanhus, the prosecuting attorney, standing in for Mr. Ward, and I'm his on the way.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Cornelius, who stands to my right. Please state your name for the record, sir.
Antonio Cornelius.
Zachary Ward on behalf of the people.
All right, I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Your Honor, the defendant will be pleading guilty to count 3 as charged, as well as adding count 4.
Well, the form doesn't, that's what I'm trying to figure out,
Okay.
because it doesn't say that, but it says the count 4, but not count 3.
Where would I add that?
Anywhere would have been better than nowhere.
You could handwrite that. The defendant would also be pleading.
Well, yes, I'll be more than happy
Yes.
to do your job.
I'm rusty, Your Honor. I'm not here to-
All right, it's the court's understanding that the plea agreement form that the defendant is going to be pleading to guilty to the stated count 3 of malicious destruction of personal property, 200 to 1,000, the 1-year offense. And also an added count 4 of attempted resisting and obstructing the 1-year offense. Upon his successful plea to those charges, counts 1 and 2 would be dismissed. And there is a consent by the prosecutor to HIDA. That is the court's full understanding of it.
Yes, Your Honor. Yes, Your Honor, that is the agreement that I have discussed with my client. He would like to accept that offer today.
May I have him sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Antonio Cornelius.
Stated his name. Sure. All right. Sir, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that your understanding?
No.
Is that your understanding, Mr. Cornelius?
Yes.
Sir, do you want to enter these pleas?
Yes.
Are you going to answer my questions then?
Yes.
You understand that you'll be pleading guilty to 2 misdemeanor charges?
Yes. Your Honor.
Counsel approach, please. Record should reflect that we've got a bench conference in the Cornelius matter. I'm going to pass the matter briefly, let him have a conversation with counsel, and then let us know when you're ready and call you back up.
Thank you, Your Honor.
Who is that? There's no one.
There's no one right there.
Okay, never mind. They may be next door, dude. Whatever, but that's okay. Court does call the case People versus Jeffrey Moore.
Zachary Ward on behalf of the people.
Assistant Public Defender Van Den on behalf of Mr. Moore, who is standing to my right. Mr. Moore, would you state your name for the record, please?
Jeffrey Moore.
Your Honor, this is the time set for the preliminary exam. This matter at this time, the people are unable to proceed.
Defense moves to dismiss.
People being unable to proceed, this case is dismissed on plaintiff, on defendant's motion.
Thank you.
Thank you.
Thank you.
All right. Court does call the case People versus Allen Ryan Hackle.
Zachary Ward on behalf of the people. Negotiate.
Emma Dadush on behalf of Mr. Ryan Hackle.
Your name, sir? Alan Gordon Ryan Hackle. Thank you.
Your Honor, this is the time set for the preliminary exam. This matter at this time, the people are unable to proceed.
Your Honor, defense moves to dismiss this case.
People being unable to proceed, this case is dismissed on defendant's motion. That's without prejudice. Thank you.
Your Honor.
Thank you, Your Honor. That's okay, Feaster. And did a much better job than you. No, she did a much more graceful than you've ever been. I just thought I'd let you know that. You know, I don't mean to call you out, but she did a great job. All right.
So this is a read, right?
I don't know.
Yeah, yes. You have two recalls. You have Dominique White, who already forget on it. Those are recalls.
Okay, and what's that?
Remands, both of them. This is who they're getting now.
Court does call the case of People versus Michael McLean.
On behalf of the people, Your Honor.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. McLean. I just may have one moment, Your Honor.
Sure.
I can still respond today, okay?
Thank you, Your Honor.
That's okay. We're reading.
Your Honor, today is the date and time set for preliminary examination. At this time, the people are unable to proceed as to count one of the asset counts 2 and 3 be remanded to district court.
We would move to dismiss, Your Honor.
All right, I'll continue as not guilty plea as to counts 2 and 3. Count 1 is dismissed. I'll set a pretrial May 14, 2025, 9 a.m. That's before Judge Perry.
And Your Honor, my client would like me to address bond.
Go ahead.
He is requesting a personal bond or a reduction in the bond. I believe it's set right now at $25,000. As the court knows, the people are unable to proceed on the felonies. They're just misdemeanors remaining. And given that she's not here, there's a chance that she won't proceed. The people won't be able to proceed on the misdemeanors either. He would be staying in the area and would comply with any bond conditions that the court may order. He is working at
The community car wash.
community car wash on Industrial. And that he would have that job if he was released.
Response.
Your Honor, I would object to any release. He was trying to violate his bond. He had 127 attempted calls to the victim while in custody with completed to her. That's why his privileges were revoked. He also has a holdout of Van Buren for failure to appear for a DV for $500. So I consider that he can't comply with court orders or his bond conditions, and I would ask that his bond remain the same.
Anything else?
What do you want to say?
I called Van Buren, sir, and they said that they don't have a holder on me.
What?
I got a number for Van Buren Courthouse, and they said they do not have a holder on me. I was let go in COVID with the certificate. That was during my marriage so many years ago. 19.
I don't know anything about the Van Buren case. I don't know anything about the Van Buren case, but he's making representations to the court that he contacted them and he doesn't have a hold there.
Yeah.
Defendant's already violated his bond conditions before this court, which is why he is where he is right now. And did it in spectacular fashion in terms of just the number of calls. So the very fact that she's not here may not be a surprise because of some of those calls that were coming through. So at this point, what I'm going to do is I'm going to deny any request to reduce his bond, let him go through the process, and then maybe Judge Perry will feel differently about that, but I don't. So motion for bond reduction is denied.
Thank you, Your Honor.
Court does call the case, People versus Quanisha Thomas.
Grab my client out of the hallway.
Allie said on behalf of the people, Your Honor.
Or you can ask him to come in, don't grab anybody.
Can't step in for that one.
What?
Can't step in for that one.
There you go.
Thank you, Judge.
Yep.
Good afternoon, Your Honor. Sydney Rushing, appearing on behalf of Ms. Thomas, who appears to my right. Please state your name for the record. Juanisha Thomas. Thank you.
Your Honor, today is the date and time set for preliminary examination. At this time, the people are unable to proceed as to counts 1 and 2, but ask that count 3 be remanded to district court.
Your Honor, we agree with that.
Okay.
They can't move forward.
I'll continue a not guilty plea as to count 3. Counts 1 and 2 are dismissed, the people being unable to proceed. We'll set a pretrial date,
May 15th at 9 a.m. before Judge Barr.
May 15th, 2025, 9 a.m. before Judge Barr.
Thank you so much, Your Honor.
Thank you. Bond will continue with its conditions. Thank you.
Thank you. Have a great day, Judge.
You do the same. All right, I got one in back.
So other than your 2 calls, I'm of the impression everything else is holding.
So how many is that?
4, 1, 2, 4.
4?
I think. Yeah. 4.
Okay. Ms. Pate, are you ready on yours?
Yes, Your Honor.
All right, let's try to get that one out of the way.
Okay.
Then I don't, what do we pass on? Oh, that's right.
Oh, okay.
Pardon?
Sending it right now.
It's okay, you're working hard. I can't depend on everybody for that, but I know I can depend on you for that. Court does recall the case, People versus Antonio Cornelius.
Zachary Wood on behalf of the people.
Wow. Was that a sneeze or just a scream? That hurt my ears.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Cornelius, he stands to my right. Please state your name for the record, sir.
Antonio Cornelius.
All right, and I have had him sworn. And so we were in the middle of a plea, and sir, my understanding is that you wanted to take advantage of this plea offer, is that correct?
Yes, Your Honor.
All right. And you understand that you will be pleading guilty to 2 misdemeanors?
Yes.
All right. First of all, this court's understanding you'll be pleading guilty to the charge of malicious destruction of personal property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property destroyed. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. Also, that you'd be pleading guilty to an added count 4 of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Now, understanding all of that, you still wish to plead guilty to these charges?
Yes.
All right. To the charge of malicious destruction of personal property, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights for today, is that correct?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium there. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Not this time.
Has anybody promised you anything other than what's been stated here today to get you to plead to these charges?
No.
Anybody threaten you or coerce you in any way?
No. No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of these offenses?
Yes, Your Honor.
On the date of March 5th, 2025, at the location of 2281 Bonesteel Boulevard, City of Ann Arbor, Washtenaw County, State of Michigan. What did you do regarding the personal property of a Jonathan West?
Broke someone's headphones without permission.
Pardon?
Broke somebody's headphones without permission.
Okay, so you got their headphones and when you say you broke them, what did you do?
Attempted to snap them in half.
Okay.
Attempted to break them.
Just break them?
Yeah.
All right. And you didn't have their permission to do that?
I did not have permission to do that.
All right. And you didn't have any property interest in these headphones, meaning you didn't own them at all, did you?
No intent of theft.
Pardon?
No intent of theft.
He asked if you owned them. Were they your headphones?
Did not own the headphones.
Okay. And these headphones, are you disputing that they had a value in excess of $200?
Yes.
You are disputing that?
No.
Okay, so that, maybe I asked the question badly.
I'm not disputing.
You're not disputing that they were worth more than $200?
Yes.
Right? Okay, I just wanted to make sure. At some point then, did you come into contact with officers from the Ann Arbor Police Department?
Yes, said they were from the Ann Arbor Police Department. They may have had DPSS caps on.
It was U of M?
Yes,
Okay.
Your Honor.
So you came into contact with officers from University of Michigan Department of Public Safety?
Yes.
And what happened in regard to your interaction with them?
They grabbed my arm. I struggled after they grabbed my arm.
You struggled with them? They were grabbing your arm to arrest you?
Yes.
And you struggled with them either to make the arrest of you more difficult or to try to stop the arrest itself or to at least do something to obstruct what they were trying to do?
Yes.
Is that correct?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's please?
Yes, Your Honor.
Court will accept the defendant's pleas, 2 counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
June 3rd at 9 a.m. before Judge Valvo.
June 3rd, 2025, 9 a.m. before Judge Valvo. Bond will continue. Thank you.
Thank you, Your Honor.
That's it for me today, Your Honor.
All right. Thank you. Good seeing you, sir. Court does call the case, People versus Sean Johns.
Ally's on behalf of the people, Your Honor.
We have the amendment.
Alex Warren, great on behalf of Mr. Johnson.
Oh, that's after the call. Okay. All right.
What? With the testimony of a police officer. Just told me this. Your Honor, today's date and time for preliminary examination. The prosecution just informed me that they are able to proceed and that they were seeking to proceed under the exception laid out in 768.27C. Relayed that to my client. I do believe my client wishes to waive his right to a preliminary examination today. I was just relayed this information, Your Honor. If the court could accommodate passing this matter, I can better inform my client of what that means.
That's correct, Your Honor. We would be looking to proceed on our 27th.
All right. I'll pass it and let you go back, talk to your client.
Thank you, Your Honor.
All right. So what?
Complaint.
Yep, I'm not.
They'll bring him out if you're
Is he-
ready.
Yeah, I'm ready. I'll do it. I'm just trying to clear up what I can. And I want to. What time's your practice?
The latest.
7?
No.
Oh.
But like, I'm saying that I get the current, so I'll get that.
Huh?
I get it out on like at 6, so I don't have to.
We'll get you there. Okay, I thought it was like. Oh.
Because I was like, what? The latest, like, there's 4:30, because I gotta get ready for class.
Got it. Court does call the case, People versus Dominique White.
And then on behalf of the people, Your Honor.
And with that, on behalf of Mr. White, stepping in for attorney Stephanie Cannon. Is there any for the record?
No, Dominique White, Your Honor.
Thank you. And I now have an amended complaint in this matter, and your client wishes to. Okay, I see what we did. We just did a straight amended complaint, and it's a domestic violence charge. Your client stands mute. Wait for a reading regarding that, or I can read it.
Yeah, no, charge. He's asking if he's doing it. I'm gonna say yes, okay? Yes, Your Honor.
All right, defendant have waived formal reading, standing mute, court will enter a not guilty plea as to count two in this matter. I'll set this for pretrial. Say again. May 15th, 2025, 9 a.m. before Judge Barr. His bond will continue in this matter. Count one is dismissed.
Thanks to me.
All right, thank you. All right, so I have four. Okay, I have four. I know which one you have.
I'm here on the hysteria. That one's going.
That one's going. And I think there are 5 witnesses on that one.
Potentially,
Got it. And then who else has the other matters?
I have one.
We have one.
That's mine.
Is that one going?
I think so, Judge.
Okay.
And that'll just be one officer under 27C.
Okay. And then is that,
I think he went to talk with his client.
oh yeah, he did. Okay, so that one may be going and then,
And then Ms. McDuffie has white, it's Constantino.
oh, that's why Constantino was standing there. Is that one going?
I just put over, so I could be.
Yeah, I know. Well, yeah, you're above the bar there. So, good. And is that one going?
Yeah, we are definitely going, I believe, 2 witnesses from the people.
Okay, so here's what I'm gonna do, folks, and I apologize about it, but our stuff are right there. I've got to give my staff a break so that they can eat. So take about a half an hour break. We will then begin. Well, I'll take the shortest ones, try to get those out of the way before getting to the longer one. Just so that you know, that is my intent. But if you're not ready to go, then I'm going to start with. All right, court's going to stand in recess.
All rise. The Honorable Judge Jason.
You may be seated. Why are you giving me the thumbs up?
I'm ready whenever you guys.
Why do you have a why do you have a bag over your shoulder and heading what?
So soon, I thought you were gonna have more time.
I told you half an hour and it's been 33 minutes.
Very prompt, Judge.
Are you ready on yours?
Oh, we got it.
All right, very good. Let's talk. That's this one, right? Court calls the case of the people versus Gervais Drake.
Allie Zend on behalf of the people, Your Honor.
Ready, Judge. Court shall please first public defender on behalf of Mr. Drake. Mr. Drake, please state your name for the record.
Gervais Drake. Thank you.
And Your Honor, today is the date and time set for preliminary examination. At this time, the people are unable to proceed as to counts 1 and 2 and would ask that count 3 be remanded to district court.
No objection, Judge.
All right, I will continue to the defendant's not guilty plea as to count 3. Counts 1 and 2 are dismissed. Set a pretrial date.
May 15th and 9 a.m.
May 15th, 2025, 9 a.m. before Judge Barr.
Judge, if I might, Mr. Drake has one request. Gosh.
Go ahead.
Mr. Drake is a over-the-road truck driver. He is currently on a GPS tether and he is not allowed to leave the state. So he's not able to make as much money as he could make if he were able to leave the state. He could.
Money in Michigan?
The longer the trips, the more money you can make, Judge. So he could make up to.
Oh.
Yes, Judge. So. So he wants to have a chance at the $40 an hour as opposed to the $20 an hour. And so he wants to know if the court might be inclined to allow him to travel. He doesn't have any problem wearing the tether. He just needs to be able to travel if the court would allow.
Response from the people.
Your Honor, as long as he has a tether on, I would leave it in the discretion of the court.
So what states is he going to?
It'd be Chicago, Indiana.
Oh, just in the Midwest?
Yeah.
Oh. Those the only two states there?
Any place?
Well,
far
you're
as
saying
I-
Ohio,
Yeah, it's not me.
Indiana, and Illinois.
It won't be Ohio.
But you have to
Oh,
drive.
you're not gonna go, well, okay, so you explain me, I'm not a trucker, but I'm trying to figure out how you get there without going through Ohio.
What states do you have to cross through to get where you're going is what he's asking.
Far as I know, those are the only two places I know for right now, information wise.
I don't know what roads you're taking. I'm gonna go by my map.
Okay, thank you. Thank you.
Cause you're gonna end up in trouble.
Yes.
So I'm gonna give you three states, Ohio, Indiana, and Illinois.
Okay, cool.
Okay.
Appreciate it.
That he can travel to those states for work purposes.
Thank you, Judge.
Thank you. Good luck to you. Stay safe on the road.
The next court date. This is my number.
Fine, we'll continue.
Okay. Can I have a copy with the 3 states you let me go through?
Well, I'll tell you. Okay.
Who's on this one?
Yep.
Well, let's get the defendant out.
Oh, damn, so.
Yeah.
Just one witness.
I spelled that wrong. I spelled Indiana wrong.
It's fine. All right.
Thank you, Judge.
We'll find somebody parity approach, please. Yeah, he's good.
Okay.
Mr. Fisher, you have a great day.
Thank you, Judge.
Yep. Did, Judge Fresh uses pink. Purple. Yeah. Oh, he uses purple. And so, do you think Fresh Out uses? All right, that may be it. Oh. I was gonna call the white matter.
And I'm sorry, Judge, I'm looking for my client. He's been here all morning. I don't know if he went to lunch or what happened.
Yeah, la da 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 da.
Sorry, I'll call him again. Which is, okay, I'm sorry.
What?
Which prosecutor's on that? Miss Docket.
I think Miss McDuffie,
Yeah, okay.
so this is like now herding cats. I should have never left the bench. Because I
I know where Mr. McDuffie is, Your Honor. Okay.
What?
I know where Mr. McDuffie is.
You do?
Yeah.
Tell her we're ready on her case. Well, I think. Because Miss Constantino just left because her client is somewhere.
He was in the restaurant.
Oh, okay. Oh, no. Then he answered his phone. All right.
Miss McDuffie?
Sam's going to get her.
Oh, okay, cool. All dressed up and nowhere to go.
Just that hard. I just need a prosecutor and a defendant. Hmm? So, Mr. Bernstein, did your conversation with Miss McDuffie, did it make it sound like it was optional to get in here, or?
She was wrapping up something, Your Honor, and I conveyed, Your Honor,
Was she next door?
she was like in the hallway. Okay, maybe I didn't convey enough urgency. I got it.
Thank you.
I was going to do.
Did you see her?
I think the victim maybe. And
You know, back when I was growing up, when I was little, you never made Judge wait.
I'm ready, Judge.
I know,
I need to, I guess I could ask to approach with counsel, or we just had something come up. That's why I was on the hallway. So I don't know if I could,
Yes, approach.
we could approach
First,
or,
or what do you want to?
or if I could either speak to counsel for just 1 second and update her on what it is, on where we are. That might be more efficient, and then we will be ready to go.
efficiency's out the door. Go ahead, talk to counsel.
Okay, thank you. You can step right up.
I had 3 cases and now Tana's gone. I know, right? No, it's okay. You don't have to go find her because I don't know that I have the other side of that in here. It's just, and I appreciate that. I appreciate the fact that you got up and you said, I'm gonna go find her. Zenda just sat there. Just, no, well, no, she didn't just sit there. She looked around. Oh, yeah, you're right. Now this is sour bird. Yeah.
They would disappear.
No. So definitely, yeah.
What is this? What's your?
Yeah.
You have white?
Right, okay.
Like 3 because this one, and this one are microphones.
Oh, Lord.
This one, you'll see the dues, just like it on the podium.
Oh, yeah.
This one. Polygon system. So that if I turn this off, anybody that's in Zoom can't hear me.
Oh.
All right. You would think that if they're red, they'd be off, but they're off. So this one you have to hold because that's for council. Right now, we're like, I'll be more than happy to call. Where is there a defendant?
Yes, Mr. White.
Oh, okay. I didn't know he had come in. Court does call the case of the people of the state of Michigan versus Kadavian White.
APA representative for the people.
Good afternoon, Your Honor. Christina Costantino, we can come up here, I guess. Stand there. On behalf of Mr. White. Mr. White, can you please state your name for the record?
Kadavian White.
Thank you.
Thank you, Your Honor. So we were prepared to hold this exam. I do have several witnesses present, but I see that there's an issue with the charge essentially. So to make it concise, this constitutional with respect to the felony charge.
That's correct, Judge. With regards to the felony charge, the defense would be moving to dismiss. It's my understanding that people are unable to proceed with regards to that charge today, and that they do not have sufficient evidence to go forward with that.
And count 2 on the complaint is currently listed as assault and battery. That should have been aggravated assault the entire time based on the facts here. I heard the court say earlier that we cannot sort of directly remand on an added misdemeanor count. So if the court needs.
Well, there just needs to be a complaint
Okay.
because it comes. Okay.
I understand. Yeah. I don't know how fast I'll be able to get that generated, but our intent is to remand on added count 3 of aggravated assault. Or added count 3 of aggravated assault.
Okay. So. And then 1 and 2 would be dismissed?
Count 2 can, Yes, it could follow or be dismissed either way. It'll.
Well, I know, I'm trying to figure out what you guys are trying to do.
I understand.
Because if you're gonna do an aggravated assault, then I'll need a complaint, just adding the aggravated assault.
Correct, Your Honor. I didn't want to move to dismiss count 3 if that was going to cause an issue in the float time between when I got the amended done. That's why I didn't know if it was going to affect it by moving to dismiss that now. I didn't want the case to basically go away inadvertently. So if count 3 needs to stay there administratively, I understand. And our amended complaint.
Okay, we could have had the complaint. I could have done it by hand by now.
Okay.
And so can we get that drafted up and just get over to us?
Oh, absolutely. But I just don't know if I can do it in the next, if it'll get typed up within the next 24 hours. That's why.
I prefer the count 2 assault and battery, to be honest. So, you know.
What do you mean you can't do it in 24 hours? Linda did it in like 10 minutes.
I will ask her how she worked her magic.
Okay, why don't we just get a new complaint and then that way we can get everything taken care of. And it can, this case can go on to Judge Washington for happier times.
We'll do you right.
But let me pass it. Let's get it done. I'll break in whatever I have
Okay, thank you, Judge.
to get it done.
Thank you.
Okay, so Warren Green is over there. This one's gonna be a remand down. And so all I have left is Ms. Kent. So who's on the other side of that case? Okay, are you ready?
Yes, Your Honor.
All right, and no, Ms. Tanner will be ready, so let's just start that. I would just apprise people that I may have to break in to take care of Miss Constantino so that she doesn't whine about it. No, I'm kidding, I'm kidding. I know, I didn't mean to say, that was what you said. That is what you said. I know, exactly. That's what, and I said she is not that way. Think you were gonna take your own note.
Is it going like 5 minutes? It's going like hold witnesses or whatever.
Court, let's call the case of the People's State of Michigan versus Darrell Hicks.
Good afternoon, Your Honor. Marie Canha, Assistant Prosecuting Attorney on behalf of the people.
Good afternoon, Your Honor. Sam Bernstein with on behalf of Mr. Hicks, who is approaching and is seated now.
Thank you, sir. All right, date and time, relatively speaking, for the preliminary examination. Are the parties ready?
Ready to proceed, Your Honor.
Yes, Your Honor. Thank you.
All right. Call your first witness.
Thank you, Your Honor. People called Deja Yargi McCoy.
Come forward and be sworn.
Before you take a seat, raise your right hand. Solemnly swear and affirm the testimony about the nothing but the truth. We're gonna see. State, spell your first and last name for the record, please.
Deja McCoy Yargi.
Can you spell that for the record, please, ma'am? Yes, please.
DEACIJAH. McCoy MCCOY-YARGE.
Okay, thank you. You may inquire.
Thank you, Your Honor. And am I pronouncing Deja? Is that right? Okay, thank you. May I call you Deja?
Yes.
Thank you.
Deja, I'm going to be asking you some questions, and after I'm done asking you questions, defense counsel might ask you some questions, okay? If anything is unclear to you, if you're not hearing what we're saying, if you're not understanding what we're saying, please let us know, okay? When you're answering questions, sometimes we get used to saying instead of yes or no. Please try to say yes or no as much as you can, okay? Thank you. Deja, do you know someone by the name of Daryl Hicks Sr.?
Yes.
Who is he to you? And you see him in court today?
Yes.
Could you let the court know where he's seated and describe an item of clothing he's wearing? Okay. Can you describe what he's wearing, please? Thank you. Your Honor, may the record reflect the witnesses identified the defendant?
Record shall so reflect as that appears.
Thank you. And you said he's your son's father. Are you currently in a relationship?
No.
Okay. And your child, your son that you have in common, what's his name? And what was his date of birth?
July 13, 2024.
And is he currently alive? Did Darrell Jr. have a normal birth?
Yes.
Any concerns with him or you during the birth with Junior? Did Darrell Jr. have any well visits with a pediatrician?
Yes.
Okay. Were there any concerns with during those well visits? Okay. I'm going to ask you some questions about what happened late August, early September of 2024.
Okay.
It's been a while since then. So if I'm asking you a question or if the defense attorney is asking you a question and you don't remember the answer, please let us know that you don't remember, okay? Thank you. Where did you live in August of 2024? And is that Ypsilanti Township, State of Michigan, Washtenaw County? Thank you. Who lived there with you?
My two sons.
And was one of those Darrell Hicks Jr.? How old was he in August of 2024? And is Darrell Hicks Sr. the father of Darrell Hicks Jr.?
Yes.
How often would Darrell Hicks Sr. see Jr., Darrell Jr.?
Often.
Okay. How often would you say? Around that time in fall of 2024?
Close to every day.
Okay.
You said close to every day?
Yeah.
And on August 29th of 2024, did you coordinate with the defendant to have him watch Darrell Jr.?
Yes.
And did he come over to do that?
Yes.
And he came over to the house you described you living at in August. And what was the purpose of him coming to watch Darrell Jr.? Okay. And so on August 29th, what time did you leave the house?
11:30 p.m.
And was the plan to have Darrell Hicks Sr. watch Darrell Jr. overnight?
Yes.
Okay, into August 30th of 2024?
Yes.
When you left the house on August 29th, how was Darrell Jr. acting at the time?
If I'm not mistaken, 29th of month.
Okay, so I know there's some confusion about the dates. So what we're talking about is the day before ambulance had to be called and he was taken away. So the day before would have been on the August 29th, when you left the house and defendant was supposed to watch him overnight. How was he acting on the day before when you left the house? Okay. Was he eating okay throughout that day? Anything that stood out to you that was concerning regarding his body movements or how he was acting? So you said you left the house August 29th, and it was sometime in the evening. When's the next time you physically came back to the house?
The next day.
Okay. And around what time approximately did you come back to the house?
I'll say 4:30, 4:45.
PM.
Yeah, yes.
Before you came back to the house, so between when you left on August 29th and when you came back on August 30th, did you have any communication with the defendant?
Yes.
Okay. Was that text message, phone calls?
FaceTime.
Okay. Was anything brought up to you as a concern of how Darrell Jr. was doing? From when you left on August 29th to when you came back on August 30th, as far as you know, was there anyone else that came to the house?
No.
So defendant was watching Darrell Jr. Was your other son present at times during that time frame? Okay. On August 30th, before you came home, was there someone else there for a brief period of time? Do you remember having a visit by someone who came to check?
The day before?
Not the day before, I'm sorry, I'm confusing you. So you left on August 29th, you came back on August 30th. Before you came back on August 30th.
Yes, the pediatrician.
Okay, was it a pediatrician or was it a different?
Social work. I know it's the University of Michigan, they do home visits.
Okay. And do you think it was a pediatrician or a social worker?
Social work.
And do you know approximately when she was there?
12 p.m.
On August 30th, the day that you came back? 11, around 11. Did you ever receive any information about anyone else being at the house? Okay. So you returned on in the afternoon of August 30th. What did you observe when you came home? Sure, yeah. So when you came home on August 30th, when you came into the home, did you see anything? Did anything stand out to you? And when you say your son, are you talking about Darrell Jr.? Okay. He was in your room? Okay.
Yes.
Oh.
It's okay.
It happens. So you come home and how do you know that Darrell Jr. was in your room?
Because he wasn't with his dad.
Okay, and where was his dad? And just to be extra annoying, when we're saying his dad, you're referring to defendant? Okay, so defendant was in the living room. Darrell Jr. was in your room?
Yes.
Okay, so what did you do, if anything, when you got home?
I came upstairs and like scared. Of course, that's how I noticed my son was in. And I went in my room to my child.
Okay, and what did you notice about your child?
He was sleeping and looked to me.
Okay. Was there anything, when you saw Darrell Jr., was there anything that caused concern?
No.
No. So on August 30th, when you came home, defendant was in the living room. Darrell Jr. was in your room.
Yes.
Okay. What brought you home at that time? What made you come home at that time?
Yes. I miss my kids. Coming out all night. It was kind of like I miss my kids.
Okay. So when you come home, Darrell Jr. is in your room. Was there something that that you noticed about Darrell Jr. that caused you concern?
Yes.
Okay. Can you tell the court about that, please?
I picked him up. And started from his bottom, and he started to smile here on my waist. And when I reached under his head, his eyes like froze in back his head. And it's like he was changing color. Like he was shaking his arms like up, a lot. When I tried to touch his arm, he My brother had silent seizures in my siblings, so I know what a seizure looks like when it's happening. So I could tell he was seizing.
So he was having a seizure. Okay. And you described, you kind of showed your arm like moving back and forth pretty quickly.
Yeah.
Is that what Darrell Jr.'s arm was doing?
Yes.
Okay. And then you said it kind of tensed up.
Yes, it's called like 10.
Okay. So at that point, you knew he was having a seizure.
Yeah.
Okay. What's the next thing that you did, if anything?
Call 911. And of course, as Darrell Senior went back.
Okay. And did he say anything about what had happened?
No.
Did you have any how were you feeling as this was happening? Okay. What were you confused about?
Because I didn't leave him.
So when you left him on August 29th, his arm wasn't twitching, it wasn't tense.
He was
Okay. Do you remember if defendant Darrell Hicks Sr. Had communicated with you throughout the day on August 30th that Darrell Jr. wasn't eating properly or keeping food down?
No.
Okay. Would it help refresh your recollection if you saw your statement to police? Okay. I may have one moment, Your Honor. Your Honor, if I may approach, this is page 6 out of 15. It's a supplemental report number 3. I'm showing it to counsel before. May I approach? Thank you. I'm going to have you just read that. Don't read it out loud, just to yourself. And then when you're done reading it, let us know. That help refresh your recollection? Thank you. So I'll ask it again. Did the defendant communicate to you that there were concerns about Darrell Jr. throughout the day of August 30th?
Yes.
Okay, and what were those concerns?
That he wasn't eating any shake.
Okay. Thank you. Your Honor, may I approach the retrieve report? Thank you. Did you have, when you came home and saw your baby and you explained already Darrell Jr. had some clear signs of a seizure, do you remember saying anything to the defendant?
Yes.
Okay, and what did you say? You asked him what he did? Okay. Did he respond to you?
Yes.
Question. Deja, from when Darrell Jr. was born until he passed, other than this incident, was he involved in any, like a car crash or anything, any accidents, anything like that? Thank you. Nothing further at this point, Your Honor.
All right, cross-examination.
Deja, may I call you that as well? My name is Sam Bernstein. I'm Mr. Hicks's attorney. I'm going to be asking you a series of questions, just like Ms. Tanhut. You know, some of them might be similar to what you've already answered. It's just part of the process, okay? So you and Mr. Hicks had like a co-parenting relationship? Yes. And could you describe that for me, please? You said you flipped days? Like you alternated who took care of Terrell Jr. on which day? Like you switched over every other day? Okay. And I think your testimony was that he saw Darrell Jr. like close to every day? Yes. Would you describe him as being involved in Darrell Jr.'s life? Yes. Did Mr. Hicks know Darrell Jr.'s routines? Did he know like when the baby slept, when the baby had a bottle?
Objection, Your Honor. She can't testify as to what Mr. Hicks knew, so maybe if the question can be repeated.
Did you observe Mr. Hicks? Like, did you see with your own eyes him care for the child? Yes. And based on what he was doing, did it look like he, knew when the baby slept? Yes. Did he know how to change the baby's diaper?
No, he had to learn.
Sure. No, I know. We have to learn how to change a diaper, but did he eventually learn how to change a diaper? Yes. And did you see him give the baby baths? Yes. And did he feed the baby as well? Yes. Did you see Mr. Hicks knowing like what Darrell Jr. would eat as far as the bottles go? Were you comfortable with Mr. Hicks watching the baby?
Yes. Excuse me one moment. Alan, can you check that hallway and tell us if they need to quiet down? Is it over there? Thank you. Go ahead.
Feels like the PD's judge. I mean, what about what Mr. Hicks was doing that made you comfortable with him watching Darrell Jr.? Had you ever seen Mr. Hicks handle his son in like a rough manner? No. Did you ever see Mr. Hicks like yell or shout at the baby? You have a son named Caden as well? Yes. And Caden was like 4 years old at the time? Yes. And did Mr. Hicks supervise Caden as well sometimes? Yes. Did Mr. Hicks have like something of a relationship with Caden too? They knew each other somewhat, yeah. Would Mr. Hicks supervise the baby and Caden at the same time? Majority no. Okay, but sometimes? Yeah. How often would they do that? Okay. And obviously, Caden was with Mr. Hicks for a little bit the evening that you went out, right? Yes. How long was Mr. Hicks watching Caden and Darrell Jr. that evening that you went out? Okay. So Caden was there the whole night? The next morning, you're still out, there's a social worker that comes over, right?
Yes.
You said the social worker came over at 11 or noon? She came at 11. Between the time that you left that evening and the next morning, you had communicated with Mr. Hicks?
Yes.
What types of communications did you guys have?
Before we went to bed. And he was putting him in the bag.
Do you know how many FaceTimes did you guys have?
That day.
Well, between the time that you left and when, and 11 o'clock the next day?
It was two. One before bed and then one with the social worker.
FaceTime with the social worker?
Yes.
Okay. Did Mr. Hicks send you communications outside of FaceTime?
No.
Were there any like phone calls or text messages? How many times did you guys call? Sure, that's fair. I know it's a long time ago. Do you remember what you guys talked about on those phone calls?
And the next day with the social worker. And we talked.
So the next morning after the overnight and before the social worker came over, did you talk with Mr. Hicks that morning? Did you talk with Mr. Hicks before the social worker came over? When's the first time that you heard about the arm twitching? You're saying the first time that you heard about the arm twitching is when you found your son later the afternoon that you came home? Did you talk about the arm twitching with the social worker? After what?
Ask questions. Yeah.
Would it help refresh your memory if you like saw the police report where you talked to the detective about all this? Like you did with Ms. Tanha? Okay. That's 8, but it might be a 6 page.
Did you need a break, ma'am? Okay, all right. Okay, go ahead. You can step down. All right. Now. We'll take a break in this case. You guys let me know when she's.
Yeah, thank you, man.
You're gonna do the other cases, Your Honor, do you think?
Yes, I'm gonna do something else, so we can take him back. I need Mr. Duffy. Yes. No, he's not. No, I know. Can we find Miss McDuffie and? Oh, there she is. Okay. He was in the other courtroom, right? That's right.
Check on Alice.
Pardon?
You want me to go check on Alice?
No.
Yeah.
Whenever, because I'm gonna, it's not necessary. Don't worry about it.
Okay.
All right, court does recall the case of the People versus Cadavian White.
If you ever to make this before the people.
Christina Costantino on behalf of Mr. White, who is approaching. Mr. White, can you please state your name for the record?
Good evening, White.
All right, thank you. All right, I now have before me an amended complaint that is regarding the charge of aggravated assault. And you waive its reading and your client stands muted.
Yes, Judge, we do waive its reading, and he wishes to stand mute.
Defendant standing mute, court will enter a not guilty plea. Or enter that his plea is not guilty. As I understand, counts 1 and 2 will be discussed at this time, and this will proceed on count 3.
Correct, Your Honor.
Yes, Judge.
Dismiss counts 1 and 2. Proceed on count 3. I'll set a pretrial date of June 12th, 2025, 10 a.m.
Yes.
10 a.m. before Judge Washington. Bond with its conditions will continue.
Thank you very much, Judge.
All right.
Have a good rest of your day.
You do the same. Always a pleasure. All right, I'm gonna. What do we, the other one, we have to wait on an attorney. We'll wait for them to let us know we're ready, and then I'm gonna take a brief recess. Court is standing in recess.
All rise.
Oh, okay.
Seated.
You may be seated. Okay. All right, man, you can come back up. Get Mr. Hicks out here. Okay. Did she say she wanted so much? Good.
I'm fine. Thanks, Your Honor.
All right, we're back on the record in the case of the People versus Hicks. Witnesses on the stand. Ma'am, I just need to remind you, and I'm sure you know, you're still under oath. All right. And if you, even though it seemed like you just did, but if you need another break, you just say so. All right. And we'll do what we can. Okay.
Okay.
All right.
Thank you.
You're welcome. To those that are in the courtroom, after I had left the bench, there were certain reports to me. I'm not going to get into all the details for who did what along those lines, but I'm just going to say this. I expect that everyone will have proper decorum while they are in this courtroom. There will not be any yelling back and forth or going at each other in any way. If I get any hint of that, I will have you removed. And I will make no bones about it. This is the only warning that you're going to get. This is tough enough, quite frankly, for this witness to testify to, regardless of where you stand on this. And that this other stuff is just not needed, and I will not be having it. So I hope everybody understands that, understands my admonition to you, and understand that I will enforce it. Mr. Bernstein, you may continue your cross-examination.
Yeah, I was asking you about the first time that you heard about Darrell Jr. shaking or twitching. And I think where we left off, I think you had said that the first time you noticed twitching or shaking was when you came home that day.
Yeah.
And I wanted to refresh your memory. Is it possible that you spoke with Mr. Hicks and the social worker about the twitching at the time of the home visit?
No, I did not.
Would it help refresh your memory if I showed you what you said to the police when you spoke with them? Your Honor, may I approach after showing this?
Yes.
Yeah.
I remember.
Okay, I have to get it back from you though, real quick. Sorry. I'll refresh my memories. Okay, so after looking at that, do you have a better recollection of the timeline there?
Yeah, yes.
Yeah, so do you remember a conversation with Mr. Hicks and the social worker about twitching and shaking?
Just to clarify, it wasn't a conversation with the social worker present, it was just me and him on the phone. She wasn't there.
Okay, so you had a conversation with Mr. Hicks on the phone about the shaking? When was that?
That was like, literally, she was walking out of the door and he called. She wasn't present to clarify that it was his nerves. That's what he told me.
I mean, did you tell the officers that you got a call from senior and the at-home nurse stating that Junior was shaking?
No,
Did you tell the detectives that, that you were told that Junior's arms were twitching?
No.
Do you remember having a conversation with the social worker that you were told that it is normal for babies to do that for the development of their nervous system? Do you remember telling the detective when you spoke with him that in speaking with the social worker, you were told that it's normal for babies to do that for their development of their nervous system?
yes,
Okay, so there was a conversation with the at-home nurse about the twitching.
after the fact, all of this occurred and going to hospital. Yes, that was discussed.
Did you discuss it? Did you discuss it with the at-home nurse?
Not that day, no.
Did you have a FaceTime conversation with the at-home social worker?
No.
Okay. Did you have any
You said
conversation?
at-home nurse, and then you said social worker. Are we talking about the same person?
Yeah.
We are, Your Honor.
I just want to make sure his question is directed.
She's technically a social worker, but everyone in the report calls her a nurse, so it's just a little
That's
confusing.
fine. I just want to make sure that we're talking about the same person.
Okay. So you don't remember having any conversation with Mr. Hicks and the social worker together about twitching? You don't remember? Is it possible that you did? Is it your testimony that the first time you heard about the twitching was Mr. Hicks telling you later after the child went to the hospital?
Yes,
You testified earlier when Ms. Tanho was asking you questions that you went home because you wanted to see your baby because you missed him? Is it possible that you went home because you were concerned about some twitching and shaking?
no,
Did you talk to the detective about, I kept hearing my baby crying in the back of my mind and felt that I needed to go home and check on him?
yes,
Okay, so why did you tell the detective that?
because I believe in God and I feel that God was calling me to go get my son. I don't know why, but randomly, yes, it happened.
Okay. Is it possible that you said those things because you were told by people that your baby was twitching and that you needed to go check on him?
No, I was never told he was twitching or nothing.
Okay. When you spoke with Detective Yeager, you said that you didn't have any concerns that Mr. Hicks did anything to the baby?
No.
You didn't say that?
Wait,
Did you tell the detective when you spoke with him that you did not have any concerns about Mr. Hicks doing anything to the baby? You didn't say that? Do you,
wait, When you say concern, you mean like in a moment of something happening to my son? No.
Okay.
I wasn't concerned. That's his father.
I want to go back to, you stated, I had asked you about talking with a detective and talking about some of the things that you said about what might or might not be normal for babies to do. Did you read that when I gave you the police report? No?
I'm all over the place, trying to take everything.
I understand. Wait, did you said you want me to refresh your memory?
Yes.
Okay. Let me just show. Yeah. Your Honor, could I approach?
You may.
Almost done. So look, I'm not trying to like beat you up here. We're just trying to figure out the timeline of everything, okay? I mean, after reading it, does that help refresh your memory that you may have had a conversation with the at-home nurse and Mr. Hicks about the baby twitching or shaking and whether it's normal or not?
All I remember is he did call me and she had got there. He hung up what she talked to me. So whatever him and the nurse discussed, I wasn't on the phone, is what I'm telling you. She never said nothing to me. It came out of the real senior mouth, what she said.
So when you told the detective that you got a call from senior and the at-home nurse, which were your words, stating that Junior was shaking, that what you said is false?
Your Honor, I'm gonna,
Oh, is it,
if we can just, I think there's some confusion, so. if
There
we can
is.
rephrase,
hold on a second. Go ahead. Stand there. Go ahead.
If Mr. Bernstein could kindly rephrase, I think we could get, and kind of get straight to the point, of asking a direct question, maybe that would.
All right. And if we could, Mr. Proctor, because I think some of the questions also can have double answers, and I don't know if she's answering what's contained within the question or the question itself, which is making it difficult for me to follow.
So. Well, let me just.
Sorry, and while I'm objecting, there's been a lot of hearsay and I've kind of let it go to
Yes.
develop testimony, but please be mindful.
Well, I'm not offering anything for the truth of the matter. I'm just figuring out the general timeline. Let me just phrase it like this, and maybe this will cut it off. Did you have any conversation whatsoever with the at-home social worker that day?
No.
Okay. Thank you, Your Honor. I don't appreciate it.
Any redirect?
Deja, are you doing okay to keep going for a little bit? Okay. Deja, how do you feel about being here today to testify?
Angry, betrayed.
This was fall of last year. Do you feel like you have a clear memory of everything or some things a little fuzzy?
Some things are fuzzy.
Defense counsel asked about defendant watching your son Caden sometimes as well.
Yes.
Before this incident, were you comfortable with him watching Caden?
Yes.
Had Caden indicated to you in any way that he was uncomfortable with defendant before this incident?
Hold on. What? Did Caden say something? My objection is hearsay, Your Honor.
Well, I don't know. It's going to be offered for the state of mind. I'm going to allow it.
Thank you. Do you want me to ask the question again? I know it's a lot. Had Caden in any way indicated to you that he was concerned about defendant being around him or watching him before this incident?
No.
Did that change after this incident?
Yes.
Okay. No further questions, Your Honor.
All right, I just have one question for you, ma'am. When you came home, you said that you went into your bedroom, right? Where was the baby at that point?
On my bed in his body pillow.
Got it. Okay, so it was on your bed and, okay,
Yeah.
thank you. All right, any questions based on the court's questions?
Fair.
All right. Ma'am, you may step. Thank you.
Your Honor, may this witness be excused?
Any objection?
No, Your Honor.
This witness is excused.
People call Dr. Carla Parkin Joseph listening.
Doctor, if you could please come forward and be sworn.
Take a seat, raise your right hand. You solemnly swear and affirm the testimony you're about to give you the truth, the whole truth, and nothing but the truth, so help you God.
I do.
See, state and spell your first and last name for the record, please.
My name is Carla Parkin Joseph, CarlaParkin-Joseph.
You may inquire.
Thank you, Your Honor. Dr. Parkin Joseph, could you please tell the court where you're employed and in what capacity?
I'm employed at Michigan Medicine, the Mott Children's Hospital. I am a child abuse pediatrician on the child protection team there.
Thank you. Are you a licensed physician in the state of Michigan?
Yes, I am.
And are you board certified?
Yes, I am.
Could you briefly tell the court about your educational and training history?
Yes, after my undergraduate studies, I completed my medical degree at the University of Toledo College of Medicine in 2010. From there, I went on to my general pediatric residency training at the Children's Hospital of Michigan in downtown Detroit. I stayed an additional year after that 3-year training program as a chief general pediatrics resident, and then continued my training in Philadelphia from 2014 to 2017, and that was for my fellowship training in child abuse pediatrics. I completed that in 2017 and then came back to Michigan and have been at my position at the University of Michigan since 2017.
Thank you. Your Honor, may I approach?
You may.
Before I do so, I'm showing defense counsel Dr. Parkin Joseph's CV, which has been sent to him already. Doctor, I'm gonna hand you what's been marked as people's proposed exhibit number 1. Could you please tell the court what that is?
This is my curriculum vitae.
Thank you. Your Honor, at this point, I would move for admission of the doctor's curriculum vitae.
Objection to that.
All right. Exhibit 1 is admitted.
Thank you. Your Honor, may I publish it to the court?
Yes.
And doctor, have you testified in court before?
Yes, I have.
Approximately how many times?
At least 50.
And have you been qualified as an expert before?
Yes, I have.
In what field?
In child abuse pediatrics.
And have you been qualified in child abuse pediatrics in this county previously?
Yes, I have.
Your Honor, at this point, I would move to qualify the doctor as an expert under MRE 702.
Could I just ask?
Objection of one here.
Can I wind you here?
You may.
Do you want to come up here?
Sure. Oh, yeah. Thank you, doctor. Just some general questions. So could you define for us the field of child abuse pediatrics, please?
Yeah, so it is now a American Board of Pediatrics certified fellowship training. So it is a subspecialty within pediatrics that focuses on all types of child maltreatment. So physical abuse, sexual abuse, neglect, medical child abuse, all types of maltreatment, and the evaluation, diagnosis, and treatment. of those conditions.
Okay, so your patients are children that are the victims of suspected abuse?
Yes, suspected victims, yes. And I'm providing an opinion regarding whether abuse and neglect played a part in that child's clinical institution.
Are you, and you're trained in like the different mechanisms of abuse, like how this stuff happens and how it relates to the body?
Yes.
Okay. And your training enables you to kind of piece together what may or may not have happened in any way?
Potentially, yes.
Okay. Well, when you say potentially, what do you mean exactly?
So at times there is a history that is provided or a potential mechanism of an injury, which I would kind of relate to the medical knowledge in the field to see if those injuries are consistent, with the ultimately diagnosed injuries as well. So sometimes there is a history that is provided to at other times, probably more difficult is when there is no history in order to really pinpoint an exact cause.
Okay, that's fair. And so if there's no history provided, there might be some limitations on your ability to say something.
Yeah.
Okay. Thank you. I'll have more questions later, but Judge, I have no objection.
All right. Without objection, the doctor is so called.
Doctor, were you involved in evaluating a patient named Daryl Hicks Jr.?
Yes.
And how old was he when the case came to you?
I believe he was 7 weeks old. I saw him.
When and how did the case come to you?
So the case was brought to my team, the child protection team, after he had been admitted to CS Mott Children's Hospital and other medical professionals had concern for physical abuse as a cause or as a due to the injuries that were identified in Daryl.
And I'll ask you some questions about that, but before I do, did you personally observe Daryl Hicks Jr.?
Yes, I did.
Your Honor, if I may approach, before I do so, showing defense counsel People's Proposed Exhibit number 2. May I approach?
Yes, you may.
Doctor, I'm handing you People's Proposed Exhibit number 2. If you could please tell the court if you recognize what that is. Yes, this is a photograph of Daryl in his hospital bed. And this is what he looked like at the time I observed him.
And when you say Daryl, are you referring to Daryl Hicks Jr.? Just to be clear. Thank you. Your Honor, I would move to admit People's Proposed Exhibit number 2 at this point.
Any objection or voir dire?
None, Your Honor.
Exhibit 2 is admitted. Thank you.
So when you saw Daryl Jr., what did you note upon seeing him or examining him?
So he did have many medical interventions that were already in place. So he had EEG, which is electrodes that are placed on the scalp in order to monitor brain activity. He also had a monitor that was actually placed inside his skull operatively to monitor pressure inside his skull. He was intubated and mechanically ventilated. So he had a tube placed down his throat in order to help him breathe. And had a number of other vascular lines, so IVs and other access.
Thank you. And what was the process in evaluating him medically? Could you tell us about that?
So in addition to my physical examination, I also gathered history by reviewing medical records. So what was available in the University of Michigan medical records. And also reviewed laboratory testing, so blood work that had been completed, as well as radiology studies. Daryl Jr. had a CT scan of his head, an MRI of his brain, had X-rays performed as well. So I reviewed those personally and with the radiologist as well.
I want to kind of take them one at a time. So you mentioned the CT scan. Could you tell us what the results of the CT scan indicated?
So the CT scan was performed just a few hours after Gerald Jr. had presented to the hospital. And that CT scan showed evidence of swelling of the brain, in addition to some scattered areas of bleeding or hemorrhage inside the skull that appeared to be between the surface of the brain and the inner surface of the skull.
And what did those injuries indicate to you? What would those suggest?
So the bleeding inside the skull would suggest potentially some trauma. And then with the swelling and the signs of poor blood flow and oxygen flow to the brain would again suggest that there was some injury that occurred.
What did you do next after the CT scan, or what was done next?
So after the CT scan, Gerald Jr. was admitted to our pediatric intensive care unit. And just a few hours after that, and actually into August 31st, he had an MRI of his brain as well.
And what is the purpose of the MRI following the CT scan?
So there are some limitations to the CT scan. It does not give great pictures of the brain tissue itself. Just to get a clearer picture of the injuries that we're seeing inside the skull, and also again to look at that brain tissue to see if there were any additional injuries.
And what were the results of the MRI?
So it confirmed again that there was bleeding or hemorrhage between the surface of the brain and the inner surface of the skull. And again, showed evidence of poor blood flow again and poor oxygen to the brain. There was pretty diffuse brain injury at that point.
And did that confirm what the CT scan had shown? And did that provide any additional information on top of the CT scan, or is it more of a confirmation?
More confirmation.
And what was the next procedure after the results of the MRI came back?
So I believe that he had the X-rays done next. We call that a skeletal survey. So it's a set of X-rays, usually about at least 20. That looks at all of the areas of his body, so from his skull all the way down to his toes and hands, and to evaluate for any skeletal injury, any fractures, broken bones.
And was there anything concerning on the X-rays?
In Gerald Jr.'s right tibia, which is the bone that you can feel in the front of the shin, but down at the end nearest his ankle, there was a bony fragment that was seen on the X-ray that suggested potentially that there was a fracture at the end of that bone.
Did you also, what did you do after the X-ray was completed?
So I believe after the X-ray that Gerald Jr. was taken to the operating room with the pediatric neurosurgery team. And that is when that monitor was placed inside his skull to monitor the pressure inside.
And what was that monitor indicating?
So at the time that it was placed, the goal would be for the pressure to be approximately 15 millimeters of mercury, but at the time of its placement, it was believed in the mid-20s. So it would suggest that there was certainly increased pressure inside his head.
Was there also an eye exam conducted?
Yes, there was.
Okay. And could you tell the court the results of that eye exam?
So the pediatric ophthalmology team evaluated Gerald Jr. And they found hemorrhaging or bleeding in the retina, which is at the back of the eye, in both eyes. Those areas of bleeding in the retina were diffuse, just meaning widespread, and really covering all of the retina. They were very numerous, too numerous to count, even to individualize each of the spots of bleeding, each of the hemorrhages. They were also in multiple layers of the retina. So they were just very widespread.
And based on your training and experience, what does that suggest to you?
So that pattern and the nature of those retinal hemorrhages is most consistent with an abusive etiology that is seen typically with an acceleration, deceleration type injury.
Is that what's referred to as kind of shaken baby or a shaking movement?
Yes.
You mentioned that you reviewed other medical records. Did you review birth records for Daryl Jr.?
Yes, Daryl Jr. was born at the University of Michigan, so there was access to that information as well as his pediatrician records as well.
And was there anything from the birth records or the pediatrician records that indicated any concerns related to or would be associated with the injuries that you saw?
Really a normal delivery and really normal pediatrician.
And when you say pediatrician records after, are those like well visits essentially?
Yes.
For the baby? And those were normal as well?
Yes.
After evaluating Daryl Jr., reviewing the medical records, taking the history, putting it all together, did you have a diagnosis? Okay. And what was that diagnosis?
Abusive head trauma or physical abuse.
Could you please tell the court what injuries were specifically consistent with the diagnosis of abusive head trauma?
The inside the skull that I described, as well as the diffuse swelling of the brain, likely secondary injury to the brain as a result of that lack of blood flow and lack of oxygen delivery to the brain. As well as the retinal hemorrhaging. Again, it was of a pattern or nature that would be most consistent with abusive head trauma. And then ultimately, with further imaging, there was also confirmation of the fracture described at the, on the right tibia.
And with the confirmation of the fracture, what's that indicative of when you see a fracture like that in a case like this?
So this particular fracture was just described as a corner fracture, which just meant that it looks like there was a chip on the corner of the bone. But at that location, typically those types of fractures are due to some shear forces at the joints, as well as tension, so almost pulling apart of that joint as well. So in the medical literature, those particular types of fractures are highly specific for abusive injury, and they have been reported to be associated with shaking, so that the extremities are kind of flailing, and then that produces those tensile and shear forces at the joints that would cause these types of injuries. At other times, the corner fractures have also been described from like a yanking on an extremity, or even picking an infant up by that extremity. So almost using that extremity as like a handle or lever.
Okay. In these types of cases, when a patient is presented to the hospital, do you instantly look for, was this abusive or not, or do you start in a more general fashion?
So yes, the medical team definitely started with a more broad differential diagnosis. So thinking about all the possibilities that could lead to the seizure-like activity that Daryl Jr. actually presented with. So there was consideration given to other neurologic causes of seizures. Did you have, epilepsy or some kind of, seizure disorder that might be causing this? there was consideration given to infection. So it's placed on antibiotics as well. But again, the imaging that was done really pointed towards.
Thank you. And based on your training and experience, what's the relationship between the severity of the injuries and onset of symptoms?
So in abusive head trauma, the more severe cases will typically present more immediately, so closer in time frame to their development symptoms.
And was this a case you would, where the injuries would be classified as severe?
Yeah.
One moment.
Yes.
Nothing further right now. Thank you.
All right. Cross-examination.
Doctor, I'm going to pick up where Ms. Tanha left off. We talked about, or she talked about the onset of symptoms. And it seems like, is it possible that twitching or shaking is one of the symptoms that might go along with these types of injuries?
Yes.
How long would you estimate that the onset of twitching or shaking would arise after such an injury like this?
I would say my best guess would be hours at most, but could be even shorter as minutes after an injury.
Okay. How many hours, like at the maximum?
With like seizure-like activity, I would say maybe up to 24 at most.
Okay. When that twitching or shaking is observed, I mean, is it fair to say that it's important to bring a child to the hospital right away?
Yes, if there's seizure-like activity like that.
In looking, in one of the, something that happens along with the injuries is that the brain doesn't get oxygen, right? And that can result in further injuries.
Correct, yes.
In your notes, in the medical records, it seemed like you had a concern for medical neglect.
Initially, yes.
You thought that Darrell Jr. had evidence of hypoxic ischemic brain injury?
Yes.
Could you explain that?
So hypoxic just means low oxygen, and then ischemic meaning that there's no blood flow. So
Okay.
what I was describing, I just didn't use those ones.
Sure. It seems like in your notes, you stated that injury presented at the time that he came to the hospital.
Yes.
And in your notes, you write that the development of like such a problem, may have been affected had the child been brought to the hospital sooner.
Yes, I think, identification of a problem and then evaluation and treatment of that problem would absolutely, yes.
Okay. Okay. You said it could potentially change the outcome. How is that? Like the treatment could reverse or not reverse, but like help prevent it from getting worse?
Yes, I believe that, yes, if he was treated in a timely manner, the medical professionals might be able to slow the progression, of that, injury as a result of lack of blood flow and oxygen delivery.
Okay. It seems like when we're talking about the abusive head trauma, the shaken baby stuff, it's the brain moving around in the skull, right? That leads to the bleeding and the swelling.
Yes.
And you had testified that often that can be from acceleration or deceleration.
Correct, yeah.
Like a back and forth movement.
Yes.
It also can come from like impact as well.
Yes.
And something like in this case that, we don't have any evidence of like, skull fracture or anything, right?
That's correct, yeah.
But this type of injury could be caused from an impact with like a soft surface.
Potentially.
Like a couch or a mattress.
Yeah.
Okay. Let me ask you about further these types of injuries. Could this be caused, if a child is like aggressively picked up from the armpits and like rocked back and forth?
I would expect the injury would be violent, and repetitive as well. So I don't think that it would occur from typical.
What about if the child was picked up and the child's head hit something like the person's arm?
If that was the only injury, I would not expect this to extend to injury.
What about, and I'm going to ask you if all these things in combination, I'll just save the suspense, could possibly add up, right? What about picking up the child's head without support and the head like flop back?
Again, I would expect it to be repetitive. So I would not expect this pattern of injury with that history.
What about dropping the child onto a bed?
Again, I wouldn't expect it to extend to injury.
But dropping a child on the bed, that could lead to the brain moving around, right?
Yes.
And once that brain moves around, that can lead to swelling of the brain?
Well, if there's injury to the brain tissue, cause that swelling.
Right. So, and I had asked you earlier if the brain could move around and like that type of scenario and impact with a soft surface. And you said that the brain could do that. And then also, I guess that leads from it that the brain could, there could be bleeding from that kind of impact as well, right?
Yeah, well, I think bleeding from the movement of the brain inside the skull, yes.
Okay. And I mean, all the actions I'm describing, in some way, there's like a lack of support to the head, right?
Yes, so the head would be basically able to move somewhat freely.
And that's part of the problem with shaken babies is that the head is not being supported while something else is happening, right?
Well, yes, there's repetitive again forces being applied to the child's head.
Right, and if there's not support to, stop the acceleration or deceleration, that's when problems arise.
Yes, that's when that bleeding happens. That's when the injury to the brain and swelling can occur.
I heard you say that you had a diagnosis. It was like a most likely diagnosis. I'm gonna have to ask you what that means, most likely diagnosis.
So I was not present and did not see immediately, before or kind of what the inciting event specifically was. But in, again, evaluating Daryl Jr. while he was in the hospital, there was what we call a differential diagnosis. So which is basically a list of possible problems that could lead to his clinical presentation. Through the course of his hospitalization, through the imaging, the lab testing, then the medical team was able to, rule out some of those possibilities. And then some of those, studies also provided support to other possibilities. So once everything was completed and injuries that I outlined previously were found, I believe that abusive head trauma is most likely diagnosis.
And we had talked earlier about like limitations in coming up with something. Were you able to read any police reports?
No, I only read police reports.
Did you have access to any statements from the parents as like the investigation went on about, admissions or statements about what happened?
I believe, yes, that I had just conversations with police about some possible histories or mechanisms of injury.
Okay. Thank you, Doctor. I have no more questions.
All right, any redirect?
Just a few. Doctor, how important, if at all, is the history you receive from, let's say, a caregiver or parent when a child comes to the hospital?
So I believe it's important, so that, that medical professionals can, kind of tailor the treatment, to, or again, kind of move those, potential diagnoses, around in that list of what's more likely. So if we're given a history of an injury or a potential injury, then, we might be able to kind of look for additional injuries, or again, kind of potentially get to imaging and diagnosis sooner.
So would it be fair to say that it's important that that history is as accurate as it possibly can be?
Yeah.
Thank you. You were asked about kind of different scenarios where the baby's head might hit a person's arm, where the head might not be supported. Would any of that describe or be consistent with the injuries that you saw in Daryl Jr.?
No.
Including the fracture to the tibia?
That's correct, yes.
And you were asked why you call it a most likely diagnosis. And of course you said it's because you weren't there, you didn't see what happened. Is that common in your field of work, is that there aren't people who are what we would call witnesses to what happened?
That's correct.
Thank you. Nothing further, Your Honor.
Can I ask one follow-up, Your Honor?
You may.
Doctor, you said you had access to the University of Michigan records. Did you also have access to the records created by Tia Braxton?
I believe so. She is part of the maternal infant health program.
Well, she is the at-home social worker that does the home visits. And were you able to review those as well?
Yes.
Did you review the notes for the day that Daryl Jr. was admitted to the hospital?
Yes.
And are you able to share what those notes say?
I'm going to object, Your Honor. At this point, that's hearsay unless there's some reason there's not.
Respond.
Well, I'm just trying to figure out how what's in those notes plays a role in her diagnosis.
No, I get that, but I'm going to sustain the objection.
Okay. I guess we'll have to ask her. Thank you.
Thank you. Anything else, Ms. Tan?
No, thank you.
Thank you, doctor. You may step down. This witness can be excused. No objection. This witness is excused. You may call your next witness.
We'll call Dr. Carl Schmidt.
Almost. Doctor, please come forward and be sworn.
Take a seat, raise your right hand. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth. So help you God. State and spell your first and last name for the record, please.
My name is Carl, C-A-R-L, Schmidt, S-C-H-M-I-D-T.
You may inquire.
Thank you, Your Honor. Hi, Dr. Schmidt. Thank you. Good afternoon. Thank you for your patience. Dr. Schmidt, could you please tell the court where you were employed in August of 2024 and in what capacity?
At the University of Michigan Department of Pathology, professor of pathology, also deputy Washington Continental Exam.
Thank you. Could you please tell the court about your educational background and training?
I'm a physician, licensed practice resident in Ohio, Michigan, and Washington State. I have residency or specialty training in anatomic and clinical pathology, then I have subspecialty training in forensic pathology, and I am board certified by the American Board of Pathology in anatomic, clinical, and forensic pathology.
Thank you. Your Honor, if I may approach and I'll show defense counsel what's been marked as people's proposed exhibit number 3. He was also sent that before the hearing today.
Is it 3? Yes, you may. Go ahead.
Dr. Schmidt, I'm handing you what's been marked as people's proposed exhibit 3. If you could please tell the court if you recognize what that is.
Thank you. Your Honor, I would move to admit the CB, People's Proposed Exhibit 3.
Any objection or voir dire?
No objection.
CB is admitted to exhibit 3.
Thank you. Dr. Schmidt, have you testified in court before?
I have
Approximately how many times?
at least 400 to 500 times.
Have you been qualified in court as an expert before?
I have
In what field?
mainly anatomic, clinical, and forensic pathology.
Thank you. Your Honor, at this point, I would move to qualify Dr. Schmidt as an expert under MRE 702.
Any objection, voir dire? Pardon?
No objection.
All right.
That's a lot of court appearances.
All right. And this witness is so qualified.
Thank you. Thank you, Your Honor. Dr. Schmidt, could you tell us a little bit about what forensic pathology is?
Forensic pathology is the branch of pathology that studies how and why people die, the changes that occur in tissue as a result of the process of death. Not only with trauma, but also with natural disease. And we also look at laboratory testing.
Thank you. And as part of the position you had in August of 2024, and I'm sorry, August and September, I should say, of 2024, did you perform and supervise autopsies?
Yes.
Could you just briefly tell us the procedure for autopsies?
So the autopsy is basically consists of 2 parts. The first is where you do a basic general exam of the body that includes things like height and weight, as well as looking for evidence of disease as well as injury. And after you're done with that, then you proceed to what is probably more popularly thought of what happens during an autopsy, where you open the cavity of the head, chest, abdomen, and pelvis, look at the internal organs, and you make a correlation with what you see in the internal organs and the external findings, if that is well.
And did you supervise the autopsy of Daryl Hicks Jr.?
I did.
And as a part of the autopsy process, would you complete a report documenting findings and conclusions?
Yeah.
Was a report completed in this case?
Yeah.
Was it completed at or near the time of the autopsy examination?
It was sometime after the autopsy exam because there were several procedures that we had to do that were started at the time of the autopsy, but could not be completed until later.
Okay. And I'm going to ask you a little bit more about the procedures in a moment. Before I do, Your Honor, may I approach, again, I'm showing defense counsel what's been marked as people's proposed exhibit number 4, but he should have that as part of the discovery.
All right. Yes, you may approach.
Thank you.
Dr. Schmidt, I'm handing you what's been marked as people's proposed exhibit number 4. Could you please tell the court if you recognize what that is?
This is a copy of the autopsy results generated in the case of Daryl Hicks.
And how do you know it's associated with the case of Daryl Hicks?
Because it has his name on it and it has an autopsy number generated as part of the Washington County Medical Examiner record keeping. It also has an autopsy number, which is the way that it's kept track in the Department of Pathology and State of Texas.
Thank you, Your Honor. At this point, I would move to admit people's proposed exhibit number 4 into evidence.
Any objection or voir dire?
No objection on that.
All right, exhibit 4 is admitted.
Thank you. May I approach with exhibits 3 and 4, Your Honor, to publish? So Dr. Schmidt, I'm going to ask you some questions about that report, but before I do, at the conclusion of the examination of Daryl Hicks Jr., was there a determination as to the cause of death? And what was that determination?
Abusive head trauma.
And was there a determination as to the manner of death in the case of Daryl Hicks Jr.? Could you please tell the court what injuries you noted on Daryl Hicks Jr. specifically that led to those determinations?
Well, the first is that he had something called diffuse subarachnoid hemorrhage. So the brain is covered by a very fine membrane, which has a very rich blood supply. And when that membrane becomes implicated, hemorrhage, that's what we say that it's subarachnoid. So basically, the entire surface of the brain is painted with this subarachnoid. Then there were scattered subdural hemorrhages. Basically, there was a subdural hemorrhage is a hemorrhage that is a clot that occupies the space between the skull and the surface of the brain. So a subarachnoid hemorrhage will sit on top of a subdural hemorrhage will be sitting on top of a subarachnoid hemorrhage. So it's a sandwich, if you will. You have the skull, then the subdural space, then the subarachnoid, and then the brain itself. Another way to think about a subdural hemorrhage is that when you open the skull, you peel away a subdural hemorrhage, whereas a subarachnoid hemorrhage is painted on the surface of the brain. A subarachnoid hemorrhage is an indicator of trauma. And in this case, it was basically all over the surface of the brain, called diffusely spread across both hemispheres, especially more weighted towards the left side of the brain. But the subdural hemorrhage extended down to another structure of the brain called the cerebellum, which is kind of like a smaller version of the brain that's seated next to the brainstem. So I guess the long and the short of it is that there was extensive subarachnoid, basically covering the entire surface of the brain, except for a small patch. Then there was what we call diffuse hypoxic ischemia. What that means is that the brain was deprived of oxygen because of decreased circulation. When this child suffered the trauma that resulted in all this hemorrhage, there was inflammation of the brain. And as the brain swells, there is an increase of pressure within the skull. The skull is basically a hard enclosure. And as the brain tries to swell, well, there's not much room for the brain to swell because the skull is itself helping to contain the pressure that builds up. And at some point, pressure builds up to the point where it exceeds the ability of blood pressure to pump blood through to the brain. So that you get we call the hypoxic injury, which is basically that loss of blood flow that happens to the brain as the increase in pressure within the skull impedes the ability of blood to flow into the brain. I hope that's.
Thank you.
And then there were patches of hemorrhage within the cortex. You will see that the autopsy report, there's something called diving confusion. That means it's a bruise that happened because of tearing or sliding of the cortex over the white matter inside the brain. It's basically two layers of brain with different densities sliding over each other as the trauma was inflicted. And when that happens, there are blood vessels that are keeping those two layers of the brain together and they get torn. So you get the hemorrhage, which we call tearing contusion. Then there was the hemorrhage in the optic, in the retinas and the optic nerve. So to do that, we look at the eyes directly. And there was hemorrhage within the retina, which is the pigment, that black pigment layer in the back of the eye. Like that was also infiltrated. Hemorrhage, there was hemorrhage in the optic nerve, the right optic nerve that comes out of the eye. And there was also hemorrhage in the neck. At the spinal, there are 7 cervical vertebrae, and then levels 5 and 7, there was hemorrhage in the nerve roots that come out of the vertebrae, out of the nerves at that, out of the spine at that time.
Thank you. Did you note anything in particular regarding the essentially the skeleton, if you will, like bones? Was there anything noted?
No, well, not in the head, but there was a fracture of the right tibia, injury to the growth plate.
Could you tell us a little bit about that, please?
So it was in the bottom of the tibia, what we call the distal tibia, it was going to the ankle, to the knee. And basically there was trauma inflicted to that part of the leg, which resulted in breaking the growth plate. And you can see that there was hemorrhage in the growth plate, and we actually removed that part of the leg and took sections from it to look under the microscope, and you could see that there was hemorrhage there.
So going back to the injuries you observed in the head, what does that indicate to you? What does that suggest to you may have happened to cause those injuries?
You can think of injury as a transfer of energy to tissue. There is no injury that happens without hemorrhage being transferred to tissue. So this is a pretty extensive injury. The diffuse subarachnoid subdural hemorrhage, intense swelling of the brain that caused the pressure of the brain to rise to a point where it basically heated blood flow into the brain. All this is a catastrophic event, which which leads me to think that something really bad happened in this child very acutely. I can't tell you exactly what it was. For several reasons. One is this child had actually survived for 8 days, 6, 7, or 8 days after he was admitted to the hospital. But this child was either shaken, that's one possibility, or his head was impacted against a padded surface. A padded surface would help spread out injury, and thus you would not see any injury on the skin as a result of being struck on a padded surface.
When you're conducting these examinations or supervising them, do you also consider the history of, did this child have a normal birth? Have there been any previous issues prior to the onset of symptoms that led to this? Okay. In this case, was there anything that had occurred, to the best of your knowledge, that would lead to these injuries from the medical records prior to this child coming to the hospital in August and September?
There was not.
And how does that play into your diagnosis?
Well, it just lends weight to the diagnosis of trauma as being the reason behind all these changes.
And you mentioned you used the word acute. Could you describe to us what you mean by that?
It means that a lot of this happened with a very short period of time. This child was apparently well until the moment that he wasn't, and then he developed seizures, became abducted, and was taken to the hospital. This happened within a very narrow period of time, which is supportive of the fact that this was a major injury suffering.
I do want to ask you about going back to the tibia, the right tibia. And you noted acute fracture of the distal metaphysis at the, I'm not going to try to pronounce all of that, but I'm referring to page 8 out of 10 of your report.
Okay.
What type of movement might cause that kind of injury to the tibia?
What? Hold on one moment. Young man. Yeah. Yep. Side, Mr. Hannah.
I'm sorry, Your Honor?
Might want to move to the side. Bring him up here. What's your name?
Ashton, you know,
Pardon?
Ashton.
I gave a warning. You were in here when I gave the warning. No, don't even try it. I saw how you walked out. I saw how you looked at him. I saw how you flipped your head. I didn't want to see that. I asked that everybody be respectful to everybody else. All right. So if you come back in this courtroom ever, you make sure you behave yourself accordingly. Understood?
Yes, sir.
You can go.
Doctor, I'm going to ask you the question again, referencing page 8 out of 10 of your report regarding the right tibia. What type of movement might cause that type of an injury?
This can only be caused by one of two things. One of them is the leg was impacted against the surface such that it caused the growth plate to get displaced. This is not a fracture like an adult where the bone hits something and because of the impact at that point, the bone splits. This is cartilage. It's growth plate. So instead of bone kinking, it kind of gets displaced, like shearing one end of the tibia over the other. And the other possibility is that it was squeezed. That's how we think these things are fractured.
Would something like a light squeeze cause a fracture like that?
No, cause a fracture like that, paralysis, I think requires significant amount of pressure.
Thank you. Nothing further.
All right. Cross-examination.
Doctor, so I want to ask you about the potential of blunt force impact. I think your testimony was that, you know, this could be shaking, this could be a blunt force impact that couldn't be excluded. Could you describe what is a blunt force impact?
Blunt force impact is when a body part strikes an object such that it can leave behind a bruise or not, but there is no actual breaking. So for example, if I strike you with my fist, that would be an example.
Okay. And that cannot be excluded in this case.
Correct.
You spoke about, in the blunt force impact, that would be an acute occurrence, right? You talked about how injuries are the result of like an energy transfer. I'm sorry if I didn't use the right words that you said.
That's correct.
How much force are we talking about that would be required to produce such an injury?
I can't tell you in numbers what actual force is needed. There is literature from the motor vehicle industry that have looked at how much energy can be generated in a motor vehicle accident. You can find dummies, for example. But in this case, suffice it to say that this is a significant injury that required a significant amount of force, just because of the extent of the injury.
And I think you had talked about how the injury is so diffuse. Could that be related to the blunt force impact on a soft surface, making it so diffuse?
Yes.
Okay. You had said that it would be a significant amount of force to result in the injury in regards to a blunt force impact, but you're not able to describe, like in numbers, what that would look like. Are there any studies or anything out there that you could point to help me read on this that would describe that, or do we not have that?
As I said, the motor vehicle accident literature does have references mainly regarding crash testing and the like.
Okay.
But this is not something that you can actually do because you can't.
Right. So it's fair to say there, and if I'm hearing you right, there's not studies on this because it's impossible to actually study it.
Correct.
There's estimates, but we don't know for sure. Let me ask you the same thing about potential shaking. I mean, do we know what type of force would be required in a shake to cause an injury?
No. No, there are papers that talk about not just the energy, but how fast the head needs to vibrate and so on. But it's obviously an experiment that you really can't do. What we know about shaking is because there have been published articles by pediatricians such as Suzanne Starling that look at cases of subdural hemorrhage with swelling of the brain that were taken from individuals that confessed actually doing this. And their value lies in that many of these stories were actually, many of these descriptions of shaking were actually obtained before there was a diagnosis of shaking.
So okay, if I could sum up then, it's fair to say that we can't say that such a shake would cause such an injury, right?
That's right.
And there's no way to really get a firm answer on that.
Right.
But you can say with medical confidence that it could be, either a shake or either a blunt force impact.
Right.
Thank you. Those are all the questions that I have.
Can you redirect?
Just briefly.
Doctor, I want to ask you about the fracture again to the right tibia. Was that fracture a fracture that had healed as if some time had passed, or was that a recent fracture?
Recent.
And as far as you were aware, and at the time you performed this, or as you're sitting here now, Daryl Jr. was never in a car accident.
Right.
Thank you. Nothing further.
All right.
No other questions on that, Your Honor.
All right. Thank you, doctor. All right. How many more witnesses do you have?
Your Honor, I actually have no further witnesses, and I was going to ask, I've had Deputy Singer waiting, and I'm not intending on calling him, so if he may be excused, I'll make sure he gets home.
All right.
Well, I'm going to call Detective Yeager then, if Ms. Tanha's not going to.
All right. So why don't I do this? While we prepare for that, you can then release your witness. I'm going to take a recess. We'll come back and we'll continue. Court is standing in recess.
May be seated. The next District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge Simpson.
You may be seated. Back on the record in the case of the people of the state of Michigan versus Darrell Hicks.
Good
And
afternoon, Your Honor. Marie Tanhas, Assistant Prosecuting Attorney on behalf of the people.
Sam Bernstein with non.
all right, and the people have no more witnesses and have rested, Mr. Bernstein.
I'm going to be calling Detective Brian Eager to the stand, Your Honor.
All right, very good. Sir, please come forward and be sworn.
Testimony about the food, whole, professional, food, State's book, first matter,
My name is Brian Yeager, Brianyeager.
All right, you may inquire.
Good afternoon, Detective. I know it may be somewhat odd for defense counsel to call the OIC when you are otherwise not called, but here we are. So this was a case that you were the investigator on, right?
Yes.
And you had several occasions to speak with Mr. Hicks.
Yes.
And on one of those occasions, that was at the Washtenaw County Sheriff's Department.
Yes.
He had come in, I mean, this is a prelim, so he had come in to do a polygraph test, right?
Yes.
And there was like a pre-interview session with Detective Babbage before that.
Yes.
And you were like observing that session.
Yes.
And you heard the conversation that was made during the conversation.
Yes.
And you ultimately wrote down that conversation in your police report, right? So, Mr. Hicks says some things that could be considered admissions against his own interest, right?
I'm gonna object as to counsel characterizing what the statement may have been interpreted as. I think there's a more direct question. Yes.
Any response to that?
I mean, that's fine. I can rephrase it, Your Honor, if that.
Thank
I thought I was skipping a
Take the
step.
objection, rephrase.
What did Mr. Hicks say regarding?
I'm gonna object, Your Honor, hearsay.
Yes. Response?
Let's try again, Judge. Did Mr. Hicks make any admissions that day?
Yes.
What did he say?
Objection, Your Honor.
Sustained.
Judge, why can't I ask what?
Because it's hearsay.
But there's statements against his own interests.
It's classic hearsay. That's one of the reasons why it's hearsay, because you can't get the testimony of the defendant in by that means. He would have to waive his right, because what protects him is his right to not testify. So you can't get his testimony in by taking it through some other means. It's hearsay. That's why the rule's there in Great Park.
But
So the objection is sustained. You can argue with me all night long if you want, but I'm telling you, it's still going to be sustained.
I just only wanted to argue for 2 more minutes, Judge. But generally speaking, when police officers get up there, they talk about what the defendant said.
Because they're not the ones.
Because the prosecutor's calling them.
Your Honor,
Yes.
if I may clarify, victim is not considered a party.
Yes.
Counsel is, as I would presume, on the side of the defendant as he's representing him, not a party opponent.
Correct. That's one analysis. See, the other was the one I gave.
Well, I guess I can't get what I want to get in, and Ms. Tanner made a good move by not calling Detective Yeager, so I think we're all done.
Appreciate the compliment, Your Honor. Nothing further.
From this witness. All right, thank you. You may step down. Thank you. I think that's the shortest time you've ever been on the stand before. All right. Any additional witnesses for the defense?
There you are.
Do I have
At
a
this point, we would move for buying over on all the counts in the
response?
I do have a response, Your Honor, and I of course, didn't get as much in as I was hoping to, which somewhat undercuts me, but it is what it is. Look, I mean, the first degree child abuse cases, People v. Maynor is the law. And that is, it's not just that a person might have an intent to commit an act. The person must intend to commit the injury that followed that act. And that's from People v. Maynor 470 Mich 289. And, Dr. Schmidt just testified, he said the cause of injury would be significant force, but we don't exactly know what amount of force a shake leads to an injury. We don't exactly know how much force a blunt force impact would have to cause an injury. The distinction here when we're talking about first degree child abuse is that the person needs to intend for the injury that follows from an act. And that's what's not on the table for your honor to consider. There's no admissions for Mr. Hicks. There's no witnesses to an act. And we don't have anything that shows that, even at a probable cause stage, there's just nothing on the table that shows he had an intent to create some sort of injury from an act.
Going to be an issue for the jury.
Well, I think it's also
making the argument that I'm to try to figure out his intent. I couldn't make that determination anyway at this stage. That's for the fact finder. That's clearly a question.
Of course, the jury instructions say knowingly or intentionally caused the injury. And so there has to be, in the Maynard case, says more than intent to commit an act, the person must intend to commit the injury that followed the act. And that's what's not present here. And that's what I'm arguing is needed for a bind over, Your Honor, that there needs to be that intent to commit the injury. That's what knowingly and intentionally committing an act leading to serious physical harm means. And that part is in the jury instructions in the statute, Your Honor. And so that's what's not present here. And my argument is that without that, there's no first degree child abuse that has been shown. There's not been shown proofs that there was intent to commit that act. They're not knowingly or intentionally would be the language.
But Mr. Frampton, if by something occurring to this child, which it did, and not immediately contacting his primary caregiver, that being his mother, that could be an indicia of some intent on his part, but not something I can decide here. I mean, that's what I'm getting at. I mean, you can, well, you argue, but that's clearly a question of fact. And
I hear what you're saying, Your Honor. I think there was some evidence that there was a meeting with a medical person at the home where this was discussed. And Dr. Parkin Joseph said that medical neglect played a role in some of the injuries that were here. And I mean, a medical person saw the baby. He was not instructed to do something otherwise. So I think there is something there, Your Honor, that shows that, he brought this up to someone and laid it out there and was not told otherwise. So it's not, did he call mom? I mean, he told an at-home social worker.
Okay, but it's still not something I can resolve.
Well, I understand the constraints that Your Honor is faced with the factual presentation here. I don't think there's enough elements there for first degree child abuse. And the charges that flow from it, I don't think can go either, Your Honor. So that's the basis of my argument.
Any response? I don't necessarily need it, but go ahead.
No, not by way of argument. I do want to make a clarification because we are going to have a transcript. So I want to be very clear.
Yes.
There was no testimony from Dr. Parkin Joseph that this was medical neglect. I want to be very clear about that.
But I think there was like a contribution of medical neglect. I mean, she said it was in her consultation notes, Your Honor.
Your Honor, it was considered, and we are all very happy that she considered all possibilities and then jumped straight to abusive head trauma. So yes, it was considered. That is not the cause of Stacy's injury. She could not have been more clear. Thank you.
I would ask the court to please consider my arguments. I think I'm on point. I think it's in this. I think Maynard supports my argument, Your Honor. Thank you.
Well, then I'll start with count 2, since that is the predicate offense really for count 1. The court believes that there is sufficient evidence to, first of all, he's the only one in the care of this child, the only one that, at least by the testimony that the court has before it, has access to this child. It is clear from the medical testimony that during that period in time, between the time that the defendant has care of that child and then mom returns to get that child, something acute, something traumatic happened to this child. On that, quite frankly, the court We've said it may be up to a jury to decide what the defendant may have known at the time, what he may have done knowingly or didn't do knowingly. But those are all questions to be decided by a jury. I can't make that determination here. Further, to the extent it needs more analysis, the issue of one's intent can be shown by what they did, how they did it, what they didn't do, what they said, what they didn't say. Any other facts and circumstances can be used to show someone's intent. A jury could come back and determine by his lack of saying anything, his lack of contact, and I'm not saying that they should or shouldn't, but a jury could come back and make that determination that he intentionally did this because something had happened to that child. Again, that's up for the fact finder. But for the purposes of probable cause, given that that could be what a reasonable fact finder could conclude based upon what I have before me, I think the people have indeed sustained their burden of showing the necessary to show the offense of child abuse in the first degree. And so therefore, the people having shown that to sufficiency for this court, I would bind the defendant over on count 2, since it is a predicate offense and there was indeed a death involved. Then the court would also bind the defendant over to stand trial on count 1. And the court also does believe that there is sufficient evidence shown by the testimony in this case that the defendant properly would be bound over and should stand trial as to count 2, murder in the second degree. Therefore, the people having sustained their burden, the defendant is bound over to stand trial on all 3 counts.
May I approach to sign the information?
In my calendar, Your Honor, I have a copy of the information, waive any further reading. Stand mute.
Defendant having waived formal reading, standing mute to all 3 counts. Court will enter a not guilty plea. Pre-trial will be set for
June 30th at 1:30 p.m. Judge.
June 30th, 2025, 1:30 before Judge Cohn.
June 30th, Your Honor.
It's a Judge Conlon case.
I do have Conlon here. Where you, well, I have the file marked up.
I was just going through the splits, but if your file says Conlon, I can give you one.
Thank you.
Looked like Conky on my little spreadsheet thing.
It looks like it on your, no, I have this as Conlon.
Okay, Judge Conlon is July 2nd at 1:30.
July 2nd, 2025, 1:30 before Judge Conlon.
Thank you, Your Honor.
Bond will continue as said. Thank you. Do you think she did your job? Meet her. What did you prosecutor? Yeah. Okay, here's what we're gonna do. I want this side over here to hang on. Let's get these individuals out of the courthouse. And then we will release you guys, okay? Get yourself out of my court.
So cool.
Yeah, everybody can remain seated. I'm gonna step off and then we'll figure out what Mr. Warren Green is going to do in my life. All right, court statement.
District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge Simpson.
You may be seated. Court calls the case of the people of the state of Michigan versus Sean Johnson.
Allie Zend on behalf of the people, Your Honor.
Good afternoon, Your Honor. Alex Warren Green on behalf of Mr. Johnson. Your Honor, today's the date and time for preliminary examination. I appreciate the court's accommodation in passing this matter earlier. I did have an opportunity to speak with my client. My client does wish to proceed with examination, knowing that the people do intend to proceed using the exception laid out in MCL 768.27C. And I think he understands that by proceeding, the people would be rescinding their offer of not adding any habitual offender sentencing in exchange for his waiver.
Okay. And sir, that is your decision?
Stand up.
That's your decision?
Yeah, my attorney said that,
Well, I don't want to know what's your discussion.
Witness. Or.
Mr. Johnson, when we spoke, I explained to you that there is an exception to the general rule laid out in MCL 768.27C, under which the prosecutor could make a showing and the prosecutor could have a preliminary examination without the presence of the person who directly accused you of this. You understand that, right? Yeah. Okay, so you understand that if we proceed right now, we are going to have a preliminary examination, right?
But you said in the back, if she
Well-
wasn't here, that I would be let go.
Okay, hold on. Because I really don't want your conversations on the record. Why don't I take a break, let you discuss with him in more detail as terms of what he wants to do. So why don't I give you about another 15, 20 minutes and you guys can figure it out. Because I want to make sure he understands what he's doing, particularly since there may be habitual offender charges that could be filed.
Thank you, Your Honor. I really appreciate the court's accommodation.
We're extending recess.
All right.
Allie, last chance, you sweetening offer?
No, that's it. That's the one.
Washington State of Michigan is not back in session. The honorable judge.
You may be seated. Because I don't want anybody to see my expression. Yes. It's okay. Judge call the case of the people versus Sean Johnson.
Allie Zend on behalf of the people, Your Honor.
And Alex Warren Green on behalf of Mr. Johnson. Mr. Johnson, can you state your name?
Sean Johnson.
All right. And are we going to have a examination? Going?
The people are ready to proceed.
And Your Honor, I did have an opportunity to speak with Mr. Johnson at length. I think Mr. Johnson understands people's position. At this time, he does wish to waive his right to a preliminary examination. The people in exchange have agreed not to add any habitual offender sentencing enhancements. Could you sign?
All right. Mr. Johnson, is that correct?
Yes.
I'm sorry, are you, I think you said yes, but your handcuffs hit the.
Yes.
All right. And Mr. Johnson, you understand. I'll let you finish signing there. You understand that a preliminary examination is a proceeding where the people would have to show by the standard of probable cause that the offense alleged was committed and that you committed it. You understand that, sir? Yes?
Yes.
All right. You understand you'll not have that hearing and you'll proceed to circuit court for further resolution of this case. You understand that?
Yes.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Mr. Warren Green.
Your Honor, we acknowledge receipt of the information, waive its reading and stand mute.
Defendant having waived former reading, stand mute. Court will enter a not guilty plea. Pre-trial in this matter will be set for
June twenty-sixth at 1:30 PM with Judge Slay.
June 26, 2025, 1:30 before Judge Slay.
Is there anything sooner than that? Please.
Hold on. Because you may be right, because that sounds like an exam help day.
I'm just giving you some willy-nilly, how you like May 22nd.
We'll get you a quicker day, May 22nd.
Okay.
Thank you, Your Honor.
May 22nd, 2025, 1:30 before Judge.
I just want to talk to my daughter, Your Honor.
Your Honor,
Yes.
I did want to bring to the court's attention, after the defendant's phone privileges were revoked last time, he did try to attempt to make a call with the same number to the victim, but the victim's number was blocked from the jail. Right? I am concerned that he tried to call that number again.
I don't want to punish my daughter.
Hold on,
Your Honor.
Mr. Johnson.
Johnson, let me just say this. I revoked your phone privileges because I felt that I had to. You would have been entitled to a hearing and the like. But sometimes, sir, what you got to do is you got to let the process work itself through. And if you keep trying to force things and do things, it's just going to cause you more headache and more problem. I'm not going to take any action on what the people are raising, okay? But I'm going to suggest as this case proceeds toward Judge Slay that you not enter into that behavior.
I just want to talk to my daughter.
I know, but you'll get there. You'll get in a position to do that sooner if you follow the rules that we have now, okay? Bound with its conditions will continue. Thank you.
Thank you, Your Honor.
What is the bond anyway?
It's $15,000 cash. And we can pass that in Judge Slay's court on the 22nd, right? Sure.
Thank you.
Thank you, Your Honor.
I'm sorry I took too much time.
No, you didn't, sir. What we're here for.